Call on the list. এই তো পরীক্ষা, best of luck.
I am
Yes.
appealing for the appellant, my lord. This is for interim order expire on 30th June, my lord. Therefore, my lord, I mentioned the matter.
What was the nature of the order we passed?
That is, my lord, in respect of the land acquisition matter, reference, our stay application was pending.
We directed you to deposit the money and all.
No, not that, because their state has filed an appeal. On last occasion, your lawsuit is directed to that appeal to be tagged with. But it was not tagged till yet, because on that day, it has been, my lord, state says it has been his appeal. Therefore, on that 20th May, your lordship has modified that order, because our appeal is pending with that stay application. That state appeal has not yet been listed.
You have challenged the enhancement.
Enhancement.
So, what was the interim order we granted you?
That is execution of that order till.
Then we'll extend that order. But Mr. Rai, you have to put in the.
That I
secure
shall,
the
my lord, let the stay application be heard, my lord. Our stay application can one is pending.
You have already served on the other side.
Yes, yes. They appeared previous occasion. On 21st April, they appeared. All are appeared.
Very well. We'll dispose of. Can 1 of 2023 is an application for stay of the execution case filed in connection with the impugned award. Push up next para. Since none appears for the respondents at the time of call, comma, we take up the application for hearing ex parte. Push up next para. Upon being satisfied that a prima facie case has been made out for hearing of the appeal on merits, comma, can 1 of 2023 is disposed of by granting stay of operation of the impugned judgment and decree dated November 29, 2017, passed in LA case number 26 of 2006 by the learned land acquisition judge, within bracket additional district judge, bracket closed, third court at Barashat, district North 24 Parganas, and all execution proceedings, comma, if filed in connection therewith, comma, till disposal of the appeal, full stop. The above order shall be subject to the appellants depositing the decretal amount with the learned registrar general of this court within 4 weeks. Within 4 weeks from date, full stop. Upon such deposit being made, comma, the learned registrar general shall invest the said amount with any short-term interest-bearing account stroke scheme with any nationalized bank and furnish the particulars thereof, comma, if so approached, comma, to the learned advocates for the parties. Full stop. The said amount shall be subject to the outcome of the appeal. Full stop. Next para. In the event of default of such payment, comma, the order of stay granted above shall stand automatically vacated without further reference to the court. Full stop. The appellants, they are appearing, you said all of them appeared?
Yes, in the state and the claimant, both are appeared. On 21st April, my lord, your lordship's order, it has.
Very well, yes. Since the state as well as the claimant stroke respondent number 5 have already entered appearance in the appeal, comma, service of notice of the appeal on the respondents is dispensed with. Full stop. Next para. Insofar, the trial court records shall be brought by special messenger at the cost of the appellants, comma, to be deposited within 4 weeks from date. Full stop. Next para. The appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellants. Full stop. Liberty to the parties to mention the appeal for inclusion in the list as and when the same is ready for hearing.
Well, the interim order is expiring on 30th of June. Malad, I was also praying, Malad, if a date can be fixed for hearing of the.
Yes, yes.
Now, what are these cans for? So many cans.
There are
Two new cans.
we have filed 2 cans. In all the appeals, 1 can is for dismissal of the appeal. Another can is for in the nature of order 41 rule 27.
It's a ingenious way, my lord.
No, no, no,
Something
my
to
lord.
learn, my lord. Your lordship on the last occasion had my lord,
Restrained them
not
from filing.
permitted them to file AOs. So now, my
My
lord,
lord,
to bring on
that may
record
be
those.
AO to stay application, but this is in the nature of Order 41, Rule 27. I
Oh,
could
yeah,
not have
it's an
relied on
ingenious way.
documents.
It's an
in
ingenious way.
application.
That will be heard along.
Yes.
That is order can 4 and can 3 is for dismissal of the appeal.
Can 3 is for dismissal of the appeal.
Dismissal at this stage. Why, Mr. Mujumdar?
Yes, my lord.
Why dismissal at
Sir,
this stage?
because my lord, the point of maintainability has been kept open in one of the earlier orders.
So
That is there,
this will also be heard along with the appeal.
Yes, yes, yes. But first, my lord, the stay application has to be heard.
documents had to be brought on
has to be-
record, my lord. That's
Maintainability on the my lord, when the stay application is taken up by your lordship for hearing, we will take a point of demur. That is already recorded. So, my lord, your lordship will hear us first.
But in that case, Lordship, kindly give us liberty to file affidavits to that. Those are doing two applications.
That we will.
Those two applications.
New applications.
No, those will, Mr. Mujumdar, we have already been satisfied. Prima facie, we have already granted a stay. Why at this stage should we change that?
My lord,
And we have kept the issue of maintainability.
My lord-
Why not maintainable, basically?
my lord, because my lord, this is an order passed in my lord, read jurisdiction governing criminal matters. The lordship is aware of the judgment rendered by the Supreme Court, where it has been held, my lord, the appeal would lie directly to the Supreme Court, Ramkishan Fauji, which has been followed by this honorable court in division bench. And now, my lord, this issue is now pending before a larger bench of this honorable court. This issue, whether at all writ is as my lord, intra-court
If
appeal
it's
would be-
pending before a 3-judge bench and this, then we'll keep it open and extend the stay.
My lord, kindly hear us, my lord. Kindly hear us. Kindly hear us. On any, my lord, your lordship may extend the stay. My lord, we are not opposing the extension of stay. But my lord, kindly keep the stay application for final hearing on some day, subject to lordship's kind consideration. We are not opposing the extension.
Can 3 and can 4 will direct here and now to be heard along with the appeal.
My lord, can 3, yes, can 3 and can 4 with the stay. My lord, stay will
With the
come up
stay.
with
Acha.
the stay.
Very well. Order of Rule 27, we are directing to be heard along with the appeal.
Yeah, yes, that is with the appeal.
Can
Order
4 of
27
2025 is an
Can
appeal.
3 will be heard along with the stay, but
Can
can
four-
4 has to be heard
Can
along
4
with
of
the
2025 has
to be heard with the appeal.
filed under Order of Rule 27 of the Code of Civil Procedure.
But so far as the last matter is concerned, there is a change in the can numbers and all that.
Given a list.
We have given a list, my lord.
না,
the
আমাকে
nature-
দাও একটা তাহলে
Any-
সুবিধা হয়। How many matter? কটা matter আছে?
This is
আচ্ছা।
so popular. This will
তাহলে এটা কেটে দাও। Please just Mr. Mujumdar, just give a list. Give the caption Order for Rule 27. Under that, the can numbers and the respective appeal.
I have given.
Column in that list.
Last column in that list.
দেখেন
These are
এইভাবে হবে।
Last column in the list is the nature
কোনটা
of that.
কিসের application?
We have indicated the nature of the application also.
আচ্ছা, very well.
but I am for appealing. Kindly give me liberty to file it.
Yes.
affidavit করছো।
Can 4 in MAT 2015 of 2024, comma, can 4 of 2025 in such and such, comma, can 4 of 2025 in MAT 2022 of 2024 and can 5 of 2025 in MAT 2030 of 2024 are applications for production of additional evidence. Full stop. The respondent shall file their affidavits in opposition. You are the respondent.
Yes.
The appellant shall file their respective affidavit in opposition to the said application within 3 weeks from date. Full stop. Reply, if any, shall be filed within a week thereafter. Full stop. The applications shall be heard along with the appeal. Full stop. Next para. Can 2 of 2024, comma, can 3 of 2025, comma, both in MAT 2015 of 2024, comma, can 2 and 3, can 2 of 2024 and can 3 of 2025 in MAT 2022 of 2024 and can 2 of 2024 and can 4 of 2025 filed in MAT 2030 of 2024, comma, being in the nature of applications seeking dismissal of the appeal on the ground of maintainability, comma, be placed for hearing along with the stay applications
ঠিক আছে।
filed in the appeals. Full stop. Next para.
Gmail আছে না?
The
Gmail আছে।
interim order of stay granted earlier stands extended till August 31, 2025 or until further order, whichever is earlier, full stop. The application for perjury being CAN 4 of 2025 filed in MAT to 2030 of 2024 along with the stay applications and the applications
That is CAN 3, my lord. I'm sorry, my lord.
and the stay you have CAN 3, sorry, CAN 3 of
CAN 3.
thank you. CAN 3 of 20 along with the applications challenging the maintainability of the appeals shall be listed along with the respective stay applications in the monthly list of July 2025.
My lord, only one request, my lord. I didn't want to intervene. My lord, so far as the Order 41 Rule 27 applications are concerned, my lord, their maintainability also may be left open, my lord.
Both
I'm-
applications.
Because, my lord,
We'll be filing
my
opposition.
contention will be, my lord, that my lord, these applications have been filed only with a view to
But in
my lord,
both the
Very well.
in both the
overcome the order which was
Needless to say, comma, the
But
question
could
of
I have relied on the documents.
needless to
in a
say,
stay
comma,
application if the
the
stay application
maintainability of the Order 41 Rule 27, comma, Code of Civil Procedure applications shall be kept open for being heard at the time of hearing of the applications.
Well, the affidavits of service, my lord.
Affidavits of service file today we kept on.
This is one big happy family, my lord.
Yes, absolutely.
it's actually a
Happy
family.
cozy family.
Actually a family also.
brothers. Their happiness should continue.
এই লিস্টের মধ্যেই থাকবে সুবিধা হবে পরে অ্যাপ্লিকেশন আসবে যেরকম বললাম
But I'm for the appellant proceed. This is the matter lordship, the will. While lordship 50% was granted to the
Just Shanal, take the microphone a bit closer to you.
in this matter lordship. Last occasion argument was closed by Mr. Prastopratim Rai. While lordship the will in respect of 50% was
Yes,
granted in to the son, and 50% lordship was granted to the daughter. Now
Mr. Chatterjee is to submit. Yes.
My lord, the founding of the last occasion, my lord directed us to serve the, or rather inform them about the judgment that we are going to cite today. But I apologize, my lord, yesterday at late night, we not be prepared. We could not.
You complete your argument, serve the copies now, they'll give reply.
Rather, may I start, my lord, Mr. Chatterjee? May I
Yes,
really
yes.
allow Mr. Chatterjee to sum up, my lord?
Yes. He had argued at length.
He had-
Mr. Chatterjee, but these judgments were to be cited.
Judgment had to be cited.
Cite the judgments and give copies to them or give the reference for them. So primarily, Mr. Chatterjee's arguments were court of conscience
of concerns and anomaly in the lordship
and no date against the attesting witness signature. Witnesses could not identify their signature in evidence. And also, second will was marked as X for identification. Alternatively, coercion in respect of the first will was admitted in the second because it was stated not of own volition. These were the primary arguments by you.
But so far as the lordship signature could not be
No,
identified,
you are not in reply. We'll hear you. Channel.
that was in
rest
respect of the
assured.
second will.
Let them just cite the judgments. We'll close their arguments and take up. Part-hard matters, we are closing your arguments then. No time.
Actually, my lord,
First part-hard matter, sorry, Mr.
I
Chakun.
was about to ask for a passover. So, Mr.
No, we are about to refuse that passover. First matter, part-hard matter, definitely no time. You have to be ready.
My lord, before citing the submissions, my lord, may I ask for my lord's leave to make two more submissions on.
Make those submissions till the judgments come.
No, no, judgments are here, my lord.
Yes.
Yeah, I hear, my lord. I just, we found.
Very well, yes.
Yesterday, my lord, we developed two arguments, my lord.
What are the arguments? Definitely you are entitled.
My lord, this first point, my lord, the propounder is the sole beneficiary of the will, and that itself, my lord, is suspicious circumstances. And, my lord, all the attesting witnesses who has
So that you say is a suspicious circumstance.
suspicious circumstances.
Yes.
There is no evidence, and therefore, as it become heavier on the propounder to discharge whenever a question of suspicious circumstances arises. There is no explanation as to how the attesting witnesses are related with the
Testator.
testator. All
Yes. Yes.
The attesting witnesses are all strangers to the executor
Very good.
and in no way related to them. Therefore, and one of the attesting witnesses is a law clerk, which they have said in the evidence. But I'll show that.
So how does it make a difference, law clerk?
Well, law clerk will are hand in gloves with the person who has with the lawyer and with not the lawyer. I shouldn't say that. The one who has put the signatures, who had.
Hand in glove with whom?
When I show that, kindly takes up the will once more. If Malawi kindly takes up. On the last page, where which will be internal page number 7. If I internal page number 7, it's written in Bengali on the top. Internal page number 7.
7, yes.
At the bottom, where the attesting witnesses have put their signatures.
Right.
And on the left, my lord will find where Binoy Ghosh had put his signature. Just above that, the read over and explain that part is there.
Yes.
May I place it? লিখিতং অর্থাৎ দাতাকে পাঠ করিয়া শুনাইলাম।
One. No, it's all right. Yes. Yes. Please carry on. পাঠ করিয়া শুনাইলাম।
Yes. দাতাকে পাঠ করিয়া শুনাইলাম এবং দাতার নির্দেশানুসারে আমার কর্তৃক ড্রাফট করা হইল। That means, my lord, it has been drafted as per the directions of the executor and it has been read over and explained to him. And just below that, he has put his signature and the date stamp is 27/9/2004. Just, my lord, 2 page before that, 2-3 page before that, page number internal page number 3. At the bottom, my lord, will find that on 10/1/2004, the will was executed. That was the point that was raised.
10/1 or 9? What is this?
10/9.
10/9 probably, yes.
So will executed. So this was,
That was your first point, yes.
The point was raised that this language that has been written, that read over and explained, this is something which is there as a format in all drafts and everything else. So this is probably it can be read over. That point was there. Now, this, may I take my lord to page number page number 79.
What is the point you are trying to develop, Mr. Chakraborty?
So the point is that the attesting witness himself says that it has been read over and explained. I'll show. At the moment I place it, my lord.
Very well. Let us come to that.
Yes. Page 79 at the bottom, my lord, see Bhakta Mandal.
Yes.
At bottom he says, I signed on the said will as an attesting witness.
Yes.
Just on the next page, at page 80. May I place it? As per the instruction of the testator, Prabhat Kumar Sarkar, the said will was drafted by Subinoy Ghosh. Now, this is the same Subinoy Ghosh who has put the signature. And the said will was drafted by Subinoy Ghosh advocate. After the contents of the will was read over by Subinoy Ghosh to Prabhat Kumar Sarkar, the testator, and after it was explained to him, the testator Prabhat Kumar Sarkar signed on the said will by putting his signature in my presence. That means, if it has been read over and explained to the testator, and the testator has put his signature after it has been read over and explained to him, that means the testator could not have put his signature on 10th. He must have put his signature on 27th, because there's a huge contradiction. That is read over and explained on 27th. Testator puts his signature on 10th. It cannot be.
Yes.
And this is coming from an attesting witness.
Right.
There is no evidence on point to clear this doubt, but this is a suspicious circumstance. And just on the next part, I cannot say after drafting of the said will by Shubinaya Ghosh, who advocate who typed the said will. On top, he said Shubinaya Ghosh drafted by Shubinaya Ghosh. At the bottom, he says, I cannot say who typed the said will. And then the will is marked up with which objection. I mean, no. Objection was there.
Yes. But he said it was drafted by Shubina Ghosh. He says he can't say who typed the will.
Now, I'll come to page 81.
Yes.
Now, I'll correlate just 1, 2, 3, 4, 5th line from the top.
Yes.
I cannot say whether Advocate Shubinaya Ghosh directly prepared the final copy of the will or gave a draft copy of the will to the tester Prabhat Kumar Sarkar for its approval.
How is that relevant?
There is no proper stand taken by the
The attesting witness may not know. See, Subinoy drafted. Subinoy had it typed by somebody. I mean, we are speaking against you. Subinoy had it typed by somebody. And attesting witness who was only present at the time of the, he said that, no, I don't know whether it was given to him for approval or directly prepared.
But the main point that I want to argue is the attesting witness says that it was drafted, read over and explained to the testator, and after it was read over and explained to the testator put his signature. Now, if it is read over and explained to the testator on 27th, then the testator could not have put his signature on 10th. It is impossible.
So that point is separate. That you have already made.
Which is my argument. And when there are contradictory sector, he doesn't know what actually happened. So probably because he has been
attesting witness not knowing whether the draft was given for approval is irrelevant. He has only to see the signatures as per section 6.
That point on 27th and 10th.
That remains. That is your best argument. So this is all. Cite the judgments.
I'm sorry. The first judgment that I'll cite.
Have you got copies of the judgments?
I have copies. I'm sorry, I don't have copies for them. Sorry.
No, you can give the citations. Those are reported judgments.
1982, 1 SCC, page 20. Page 20.
Yes. Any particular paragraph, Mr. Chakraborty?
Yes. Number para 7. First, may I place this is on the onus of the propounder. It is always the onus of the propounder to make sure that the conscience of the court is satisfied first.
Yes.
Once the conscience is satisfied, then the court may go into evidences that has been laid down when there's a challenge or not. That is the secondary.
In the absence of suspicious circumstances, ordinary proof would do under 63.
My lord.
But if there is suspicious circumstances, the burden becomes heavier.
My lord. Can it takes up directly para 7?
Yes.
Now, may I place it?
Yes.
This court has held that the mode of proving a will does not ordinarily differ from that of proving any other document except to the special requirement of attestation prescribed in the case of a will by section 53. But
Whoever, yes. Let him settle down, Mr. Chakraborty. In the meantime, we continue.
I'm sorry, man. I'm sorry. We point out ownership. Onus charge, 1981. Now, the onus of proving the will, I'm sorry, my lord.
Actually, we have read the paragraph in the meantime.
I'm
So
so,
need not place it.
so sorry, man. May I place it, man?
Any other paragraph? This we have read. We have read the entirety. The onus is on the propounder to
My lord,
explain
my lord,
to the
my lord,
satisfaction of the court. If doubts, then completely removed legitimate suspicion.
Yes. No, 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 my lord. আচ্ছা, ঠিক আছে।
Yes, yes, Mr. Rich.
Lord,
2021.
there was this argument, Lord, which was made by my learned friend, senior friend. That Lord remembers the anomaly, Lord, which was there, Lord, in the will. Lord, it was
27th and 10th.
and
It was shown by
my-
Mr. Today also. Yes.
it was, Lord, the submission which was made by my learned senior friend, Mr. Rai, was that, Lord, he did not get an opportunity to explain it, since I had not taken that in the pleadings. Now, my lord, he cited one decision which I'll come back to. He wants to say, my lord, that since this was not pointed out, I did not explain. But he's not prayed for, my lord, any chance here before your lordship to explain. He said that I did not get a chance to explain. The law that the Supreme Court is now saying, my lord, is that even if there are no pleadings, even if there are nothing to show, even if there are no objections taken, because this is a court of conscience, it is a duty cast upon the propounder to explain whatever is there. This is 2021-11 SEC, page 209. Takes up, paragraph. 2021-11 SEC.
Para 24 first.
Kindly have a look at first para 24. ওখানে dot করা আছে। আমার আইপ্যাড আসবে না সময়ের মতন, ঘুমিয়ে যাচ্ছে ওখানে। আমি কি দুটো লোক রাখো, চারটে লোক রাখো, doesn't make a difference.
22, yes.
Kindly takes up, Lord, paragraph 24. My lord need not trouble my lord's self with the entire.
Yes.
Very interesting part, my lord, which is again very common, is something which your lordship will find, my lord, at 19, which is quoted from another judgment of Venkatachala Iyengar,
Yes.
24.1.
Yes.
মাথাটা এবার খারাপ হয়ে যাচ্ছে আমার। Lord, what I was trying to, Lord, canvas is, Lord, if your lordship turns to, Lord, 260 at 12.5.
260.
Yes, Lord. If a person challenging the will alleges fabrication or alleges fraud, undue influence, coercion, etc., in regard to the execution of the will, such pleas have to be proved to him. This is, Lord, his submission. Then, but even in the absence of such plea, the very circumstances surrounding the execution of the will may give rise to the doubt or as to whether the will had indeed been executed by the testator, and or as to whether the testator was acting of his own free will. In such eventuality, it is again a part of the initial onus of the propounder to remove all reasonable doubts in the matter. Lord, I'm on this. My lord, this was an anomaly which was there on the face of the will. Even if I have not proved, my lord, the court has found it. It is for him to, my lord, prove it's his onus to discharge. My lord, then my lord, your lordship has seen 1982-1, my lord.
Yes,
Your lordship takes note of paragraph 7, that was on onus.
we've seen that.
This is the judgment, my lord, on that. Then, my lord, your lordship takes 1998, volume 4 SCC, page 384. Have a look at paragraph 4. The law is well, my lord, can you- the law is well settled that
Yes.
that the conscience of the court must be satisfied that the will in question was not only executed and attested in the manner required under succession under the Indian Succession Act, but it should also be found that the said will was the product of the free volition of the executant who had voluntarily executed the same after knowing and understanding the contents of the will. Milord, may I stop here for a moment? They relied on a will which was marked X for identification and where it is stated যে আমার ওপর ঝামেলা করে এটা করিয়ে নেওয়া হচ্ছে. So this is on that, my lord. Therefore, whenever there is any suspicious circumstance, the obligation is cast on the propounder of the will to dispel the circumstance. As in the facts and circumstances, my lord, your lordship need not trouble, my lord, sir. So, moment, my lord, there is a suspicious circumstance, be that whatever it is may, my lord, it is for the propounder, my lord, to explain it. And then he discharges his onus. In my respectful submission, my lord, in our case, he has not done that, not even attempted to do that. Very two important things, my lord. The witnesses, my lord, your lordship will find, are nowhere related, my lord, to the propounder.
Yes, that was.
Your lordship has seen that anomaly as well. And in the second one, my lord, he has said that I don't even know, my lord, when the will was signed. So this takes the totality of the situation. That is what, my lord, is there in 2021 as well. Lord, your lordship will look to paragraph 25. The Supreme Court says, while granting the probate, the totality of the circumstances need to be taken into consideration. Lord, I have another judgment. 1974. Huh. তাহলে জজ সাহেবকে এতে দিন না, আইপ্যাডে দেন। Lord, this is a 3 judges bench decision.
Yes.
1974, volume 2 SCC, page 600. Lord, the one is the book, Lord, the other one is digital. Lord, you see the digital, Lord, the
1974
volume 2 SCC, page 600.
Oh,
They are
achha.
similar line.
page.
600.
Give us half a minute.
Mal.
আমার ট্যাবটা রয়েছে বললা চালু করা হয়েছে কিনা মনে আছে
Lord, I can airdrop it, Lord, if your lordship wants. Justice Boshak on the other day, Lord, said that please airdrop because it's easier for me. Because the papers in his court, Lord, goes from here, there, out everywhere.
Yes.
So he said it's best that you airdrop it to me so that I can look into it.
Or hard copy.
You have got photocopies.
Yes, we've got it.
And even my tab is not loading. So Wi-Fi issue.
Maybe the Wi-Fi, my lord, is. But if your lordship, if it's an Apple, my lord, then it will go without the Wi-Fi.
Not an apple. Orange.
Then it won't go without.
Usual orange. এই আপনি একটুখানি বলে দিন ওয়াইফাইটা কাজ করছে না কাউকে দিয়ে খবর করে দেবেন ওটা ওয়াইফাইটা কাজ করছে না আমি পাচ্ছি না
Paragraph 7. The propounder has to show the will was signed by the testator, and that he was at the relevant time in a sound disposing state of mind, that he understood the nature and effect of the dispositions, and he put his signature up to the testament of his own free will, and that he has signed in the presence of the two witnesses who attested it in his presence and in the presence of each other. Once these elements in his presence and in the presence of each other, once these elements are established, the onus which rests on the propounder is discharged. But there may be cases in which the execution of the will itself is surrounded by suspicious circumstances, such as where the signature is doubtful, the testator is of feeble mind, or is overawed by powerful minds, circumstances, the dispositions appear to be unnatural, improbable. My lord, I go back to that document which Mr. Rai relied upon. Overpowered by powerful minds.
Why powerful minds?
My lord, he has stated that the gentleman,
Volition, not of own volition.
not on his volition,
Due
and
to-
then
due to
he
his
said that
pressure.
আমাকে করতেই হবে, pressurize,
All right.
Ashanti. That's the word taken, Ashanti. He was of feeble age, my lord, old age. The son, extremely rowdy. But for Ashanti, I am doing this. This is what is there, my lord, in the document Mr. Rai relies upon. And again, my lord, it goes on with the quality of proof and things like that. My lord, if the totality of the decisions which I have cited, if your lordship sees, the law is, it's not, yes, a will has to be proved like a normal document. But there are special cases where, my lord, where 63 has to be followed. And apart from 63, because it's a court of conscience, the usual, my lord, what the procedure is may not be followed. If the court needs to be satisfied that this was done out of his own free will.
But Mr. Chatterjee,
My lord.
even if the court was of that opinion, shouldn't he have had an opportunity? Because
He
if
never
at the judgment
that.
stage, how does he know that's a suspicious?
Okay, before your lordship, all these days, my lord, he's never
No,
paid.
we are sitting in judgment over the trial court's
My lord.
decision.
My lord, your lordship knows this is first appeal, my lord, order 41, rule
True,
33.
but even before the trial court,
This is a court of fact.
how could the finding of the trial court be justified that this is suspicious circumstance?
Because
We won't arrogate ourselves to the first court and take evidence.
my lord, I completely bow down.
That
My
will
lord.
require
In
a remand.
normal situation, yes.
But the
My lord,
trial court should have done that then. If
No,
if it is of the
what
opinion that yes, there is a
respectfully,
discrepancy.
sir, I bow down, my lord. I started off by saying that. My lord, if your lordship remembers my submission, my lord, when I started, I said that yes, this would have been a question of remand, but Mr. Rai has never even said. Mr. Rai, my lord, has never even made that submission. That yes, this is. He says that this was never taken. This is not there.
And he tries to explain away by saying that that was the date of the
Exactly.
notarization
So he has tried to explain it before your lordship.
on the materials which are on.
My lord, on the materials which is required. So, appellate court, my lord, we go back to Lord Rankin, my lord, will not shirk its responsibility, especially when, my lord, he is not praying, he is not saying that I have other evidences to show that that was not a suspicious circumstance. He is accepting the circumstance and saying that this is not suspicious. This is the distinction in my respectful submission, my lord, for your lordship's kind consideration. I will show, my lord, each judgment that my learned senior friend has cited, my lord, is in my favor. He had cited probably for some other proposition, but basically, my lord, it goes to the root of in my favor.
All the judgments go in favor of both the parties, whichever way you look. Because the
I-
propositions are the same.
Bow down. But he has brought in, my lord, judgments from the Hindu Adoptions Act, from my lord, from a money degree. Well, now, I'm sorry.
Yes.
My lord, there are two decisions of the division bench of this court, my lord, but I'm not citing them, my lord, because there is already a Supreme Court. I need not, my lord, trouble your lordship, and more so because the author of those judgments, I don't want to cite them
Why?
with this court. Then, my lord,
Why?
kindly.
It shows you're tickling your.
That's why Do
And
not.
we have already cited, if on the same proposition, Mr.
I
Chatterjee, need
don't
not-
want to because
because
it's on
probate
that.
matters, we see several judgments are cited on the same proposition.
That's why I did not.
Proposition is this, there is no doubt on this.
I don't want to
If
cite
there is a
them.
suspicious circumstance, even the court can look into it of its own,
Exactly.
and definitely they have to
Even
explain.
without pleadings. That's why I cited 21.
Yes, court of conscience
For
theory,
conscience.
yes.
See, my lord, Mr. Rai's judgment. First one, my lord, is 2015 Calcutta 106. It's there with your lordship, my lord.
Yes.
Comes in, my lord, from this is from a money degree. He has cited, my lord, paragraph 7, if I'm not mistaken. Right.
We don't find any paragraph here.
Yes, I don't know, my lord, from
This was on third case being made out. Probably.
that's right. This is the third case, my lord, which your lordship will file in internal page 4. Mr. Dhruva Ghosh submission.
Yes.
So this is completely distinguishable, my lord. If that was a money suit between two parties on a contractual basis, and a third case was made up. This was not, my lord, in a probate proceeding where, my lord, the court is a court of conscience, and even without pleadings, the court can look into it. Completely distinguishable. Then 2006 volume 13 SCC 449.
Yes.
He has cited paragraph 20 on onus.
Right.
Looks to that paragraph. My lord, your lordship, remember, my lord, Venkatachala Iyengar was referred to in that judgment, my lord,
Yes.
of 2021. This is referred to, my lord, in paragraph 17 of this judgment.
Yes.
And the same thing which I quoted, which I read for your lordship, there is here also.
Here also.
So that goes completely against him. And then kindly switch to 20. He has relied on 20. I don't know, my lord. It is quoted from another judgment, which is, my lord, reported in 2005, volume 1 SCC, page 40. Will being a document has to be proved by primary evidence, except where the court permits a document to be proved by leading secondary evidence, since it is required to be attested as provided in section 68. It cannot be used as evidence until one of the attesting witnesses at least has been called for the purpose of proving its execution. If there be an attesting witness alive and subject to the process of the court and capable of giving evidence, in addition, it has to satisfy the requirements of 63 in order to assess as to whether the will has been validly executed and is a genuine document. The propounder has to show that the will was signed by the testator and that he had put his signatures to the testament of his own free will, that he was at the relevant time in sound disposing state of mind and understood the nature and effect of the dispositions, and that the testator has signed in its presence of two witnesses who attested it in his presence and in the presence of each other. Once these elements are established, the onus which rests in the propounder is discharged. But this is where the other part comes in. Where there are suspicious circumstances, the onus is on the propounder to remove the suspicion by leading appropriate evidence. The burden to prove that the will was forged or that it was obtained under influence or coercion, fraud is the person of whom he alleges it to be.
The next sentence is also there in his favor.
Yes, brother. It is in his favor, which is then qualified by that 2021 judgment.
But in this case,
In this case, it does, my lord. In 2021, it says just, my lord, in my
no,
favor.
not only that, in this case, it was held that the single judge and the district judge were right because the discrepancies were glaring on the face of the record.
Mal.
Therefore, no interference.
Mal.
Could not have been ignored by the division.
Could not have been ignored. This is what it is. It casts a duty on the court to look into it. Forgets about, my lord, everything else. It is SBC no judgment, yes.
ওয়াইফাইটা না মাঝে মাঝে আসছে আমি দেখছি কি হয়েছিল? কানেক্টিভিটি আসতে সময় লাগছিল নাকি? ঠিক আছে, থ্যাংক ইউ।
Ah,
This
The-
by itself is not an indicator, but
space which is, my lord, your lordship,
space is left because I mean,
wherever
the
there was
content ends
space,
before that.
my lord, I feel, my respect, I'm not an whatever experience I've gathered, my lord, when there is a document which is to be prepared after somebody else has signed on it, my lord, your lordship will see that there is a particular amount of space which is left for the ingredients to be typed into it. Here
That
is a,
depends on where the
there
typewritten
would
portion
have been,
ends.
my lord, once it's
Why should it be? They should sign at the end.
I'm not saying
The attesting witnesses was signed beside the.
I'm not on that.
Yes.
Below the spacing in the between the lines at the top and the spacing in the bottom of the page are different. Spacing means between the two lines, the space which is given at the top, it is different.
No.
There is equal. After the signatures come in, the signature comes in very up. Milord, if your lordship sees, I'll একটু জজসাহেবকে দেখাবি।
Yes, what is the difficulty there? We don't
Huh.
understand.
But হ্যাঁ, এইটুকু জায়গা ছাড়া ছিল, সের মধ্যেও সই করেছে। Lord, if your lordship sees, this part,
Yes,
original
perfectly all right.
Original
No, original need not be because it's a photocopy.
My lord, Lord, এই উইল খানি নিখিতং অর্থাৎ দাতাকে পাঠ করিয়া শুনাইলাম, লর্ডশিপ, that part.
Have you ever seen our judgments? The signature of the first judge and the I agree. Exactly same. That depends on the typeist, Mr. Chatterjee. This does not create a suspicious circumstance.
I say, Lord, the spacing is different. Your lordship decides on this.
All right.
I am not, Lord, really, Lord, getting it, because this was again not, Lord, there in the trial court. But be that as it may,
Better deal with the third judgment on third case.
বলেছি তো সেকে এই জাজমেন্ট গুলো all on that he takes up active participation and he is the entire beneficiary. Active participation and entire beneficiary. None of the witnesses are close below to the testator.
Yes, active participation of the propounder.
Propounder.
And he's the beneficiary. Mr.
Beneficiary.
Chakuta argued that. Yes.
All the judgments have said so. All the judgments which I have cited, it said so. He needs to explain away, Milord.
Why do you say he was an active participant?
He
In
was
what
there,
sense?
Milord, all throughout. All throughout he was there.
What do you get that from the
The
evidence?
problem is, Milord, that the one who is the witness are not people who are known to the
Not
Milord
known
propounder.
people, yes, that you have said.
They are not known to the family itself, which itself is a matter of problem.
And one is a law clerk, he says.
He's a law clerk. He has said in his evidence that he's a law clerk.
So law clerks are suspect.
A law clerk, Milord, who doesn't have any relationship, Milord, with the family,
Maybe the law clerk of the scribe, or he's somebody.
doesn't become a witness.
You
because-
draft a will, Mr. Rice clerk signs it. I mean,
in my will, I don't have a problem on that, certainly. But then there has to be that relationship between the two of us.
with the testatrix and law clerk need not be. You can ask your advocate to bring the attesting witness. That is not a suspicion. That happens many cases, Mr. Chatterjee. You know that.
So, my lord, this is what it is.
Yes.
My lord,
And what about the third judgment cited, Lokhi Bai?
third
Lakshmi
judgment
Bai.
মানে? কোনটা?
2013, that's also on third case.
Same thing.
Money.
হ্যাঁ,
The
no,
Hindu Adoption Act.
Adoption Act. He has probably cited paragraph 40. I know one, Lord.
Yes,
I'll
40.
take your lordship to that. Correctness of the state of a witness. The witness should be given a chance to explain.
Yes.
This is below. Thus, if a party intends to impeach a witness, I'm not impeaching any witness here.
All right.
He cited for that.
So that is all, Mr. Chatterjee.
দেখিয়েছিলাম আগে কি? There's one just line that we need to show.
Yes.
Paragraph 85.
Which judgment?
No, below of the paper book. This is the below the witness of the deposition of witness number 3 for the plaintiff. Kindly see page 85 once. Yes, we should have shown this.
85, yes.
The court asks a question. Shubinoy Ghosh had prepared handwritten draft of the will. I cannot say at this moment who typed the will. I did not go through the contents of the will. It is a fact that the date of execution is 10 September.
Who says this?
This is witness number 3. Witness number 3, Milord.
Who typed the will, he may not know.
No, he is the Milord
Vinay Ghosh might not himself type it.
attesting witness.
Attesting witness, why should he
I
know
don't
who
know, but
typed,
he-
who
no,
drafted
the,
and typed?
the date,
He has to see only the testator's sign.
the date he says that it's been executed
Yes,
on 10th of September.
maybe.
And the other witness is saying, Milord, the other date, October.
Who is saying October?
Yes.
Kindly looks to that. He is
Please,
saying, Milord,
sure,
it is read over and explained on the other day.
It does not say on the other day. It was placed by Mr. Chakraborty that he says after it was read over and explained, then his testator's sign.
That is in October.
No, he does not say October.
No, that's from the will, Milord. From the will.
Both are September. Both are September. One is 29th or 27th. Other is 10th.
Yes, Milord.
So,
Now, October, so.
yes.
Milord, can you turns back to the will once?
Yes.
September.
27th September
27
and
September
10th September.
and 10 September. Yes.
So you are
Sorry,
you are
not
trying
October.
to say that since that is again based on the signature date
Mal-
of the scribe. Very well. Thank you. Yes, Mr. Rai.
জাজমেন্ট দেখালি দিলি না তো জাজমেন্ট গুলো যেগুলো দেখালি
সবই তো তোর ফেভারিট।
না না তুই যেগুলো দেখি আলাদা কিছু দেখাচ্ছিস তো
No. It was actually prepared at late night, Milord. That's why we couldn't give it.
No,
to
no,
him.
no.
But Mr. Rai knows these judgments by heart, so he doesn't need it.
Yes. Propositions are the same. No difficulty on that. Now, what is your answer to this? Only point which is irking us is that
27th
27/10th there is palpable discrepancy and testator signs. The explanation which was you were trying to give to us. So Chatterjee has a point that yes, trial court might not have given him an opportunity, but some of the judgment cited says that the court may. Justice Sinha's judgment says court may.
then court
It is
has
not
to
said whether after that it has to be given you have to be given an opportunity, but we deem that it has to be given. In the appeal itself, throughout the pendency of the appeal, you did not take out any order for 27. But you say that you are trying to explain on the
facts of the
document itself
any subsequent document for the purpose of or for the purpose
or evidence, oral evidence.
evidence one of the person who was there is now is no more in the world.
Who is not there? Scribe is not there.
Yeah, he died.
Oh.
Scribe is not there. Witness could ask.
Anybody is alive.
Yeah.
At a witness, scribe.
Scribe died only because he was advocated to us. That is why I can submit before Lordship.
All right. Yes.
And so far, if your Lordship can consider the date, which is considered by the learned court below for the purpose of rejecting my application, that your Lordship will find at
10th September.
118. My Lord, can you consider 118, page 180 of the paper book?
Our factor argument.
না আমি একটা জায়গায় দেখাচ্ছি যেটা
Yes, 180.
this was the date which has been considered 10th and 27th because I want to dispel that. Now my Lord, can you turn to 119? Why? So the signature Subinoy goes along with the date was identified. Page 119, my Lord, consider.
119 years.
That was the consideration for the purpose of the court for holding that apart from that, my Lord, kindly on the page 84 approval to this.
Now, 119, what hinges on that?
Then Subinay Ghosh, along with the date, was identified. It was the case as if the court is of the opinion the date was also identified on the same date. Now, my lord, can you consider 84? আমি দেখাচ্ছি তো হ্যাঁ আমি দেখাচ্ছি তো
Yes, 84.
at the middle.
Hmm.
Last portion. This is the signature Subinay Ghosh on the said will. The signature of Subinay Ghosh is marked exhibit 1/3. It is not a case that whether the date is appearing on the will is also is not the date when the deed was executed. Only the signature which has been identified on that day. The court.
May I once interrupt? Look, kindly have a look at, for the sake of, since your lordship is on 84, have a look at 86 once. Because for the sake of continuity, my lord,
Yes.
looks to the top.
Hmm.
I do not know the wife and daughter of deceased Prabhat Sarkar. I cannot recollect my memory and say whether I signed on the will as an attesting witness executed by the deceased Prabhat Sarkar on 23rd March 2006.
This is their will.
I cannot say whether the signature is of myself or not.
That is your will.
That is his will.
Yes.
How does that matter?
He cannot say.
You cannot say about your will, not this will.
I can recollect from my memory and say
That is about their will,
their will.
not this will.
And
Yes, what else, Mr. Roy? Complete your argument.
yes, yes. And so far, my lord, if you logically consider the
No, my lord, it's not about my will.
yes.
Nobody's case is that any will was executed on 23rd of March.
It was, if your lordship sees from the courts, my lord, which I was,
23rd March, what happened? This will is of 27th of
that's exactly what I'm saying. That's, my lord, if your lordship sees 85,
That
that's
is
why I wanted Mr. Chakraborty to see the original, whether the date has
Page-
been given is wrong.
page 11. My lord, can you turn to page 11 of the not the volume page 11 last. Because at the bottom, my lord will find the date.
Yes.
It is a will executed in favor of the daughter. That was probably on the earlier occasion. My learned friend pointed out that it was not been marked exit, but from the order impugned, my lord, your
Just
lordship.
second will.
Second will, 109.
Yes, it's understood.
109, your lordship find from the paper book.
Very well. Yes. What else?
My lord, so far, my lord, the case has to be made out for the purpose of suspicious, and on the court as the court of conscience should be put. If the court is of the opinion, yes, there is discrepancy regarding the signature and other things, then my lord, I could have understand. Yes, I can explain that situation. There is no question put forward by the cities, no objection raised, nothing. Only the sole objection, my lord, will find that is a subsequent will that will liable to be probated. So earlier will cannot be probated. That was the only consideration. Apart from that, my lord, so the active participants of the propounder. But if you logically consider, he is not given the entire property to this to his son, but 50% property is given to the mother and the daughter itself. So there is no, my lord, creation of will itself, my lord, is a curtailment of general succession.
You have got only a portion of the property.
I am getting a portion of the property. And if I don't want to draw your lordship the schedule, the petroleum and other things which are the business like was given to the mother. And the persons who are my landed friend, though it has not been question put forward, they're all associates with this Prabhat Sarkar in the business. That is why Meher Ali will lordship will find is attested in both the will.
Has it come up in evidence?
Yes, because DW3, that is why this question was put forward that whether
Was
this,
that portion?
yes,
Page?
my lord, DW3 page, sir. PW3.
PW3.
PW3. No, P for partner. 83.
Yes.
This Meher Ali Sheikh is the attesting with both the will. And that is why a question put forward whether you know that on such as a will was there and put your signature as a district witness. That is why in reply to the same, my lord.
Is it said business associate?
Yes. বিজনেস অ্যাসোসিয়েটস কোথায় আছে এটা ইয়ে করতো বিজনেস অ্যাসোসিয়েটস ওই যে সম্পর্কটা এখানে আছে পেট্রোল পাম্পের ইয়েতে ছিল দাদা পরেরটাতে আছে পরেরটাতে এক মিনিট দাঁড়ান দেখি
Prabhat Kumar Sarkar is the testator.
ইয়েস
Page 85.
Business associate to have.
Not business associate.
And know him very well is also there at 83.
দেখতে অষ্টআশি পেজ ওইখানে লেখা আছে আর ভক্ত ঘোষ
ভক্ততেও নেই।
না 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 আই নো ভক্ত ঘোষ পার্সোনালি না 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 মানে ইয়েস থ্যাংক ইউ আমি রেসিডেন্ট অফ where the this is Prabhat Kumar Sarkar also used to
ট্রানজাকশনটা নেই বলে।
business transaction নেই মনে হয় yes I beg to be corrected
What about Bhakto?
ভক্ত
Employee of Krishnanagar Bar Association.
law clerk.
law clerk I will
He has not said that he is the clerk of Subina.
no
সাক্ষী।
জাজমেন্টে পাবো মনে হচ্ছে দাদা ওই জাজমেন্টে লিখেছিল পার্টিশন স্যুট যখন করেছিল সেটা রেস্টে
what is the sign in the bill
Is there any evidence to show Subina was a member of the Krishnanagar Bar Association? There is not.
evidence তো কোথাও আসেনি
They have said that he was an ex-MLA.
and also an advocate practicing advocate তো ইয়েতে পারবে না
Yes.
চিকেন নেক কার চিকেন নেক হ্যাঁ কার চিকেন নেক
না না তুই একটা 22 ফুট ফাইল করেছিলি সেটা বলতে
না দুজনেই
জানি আর কি
দুজনে
তুই মিটমাট করছিস না? সবাই মিলে আধে
বেছে দিয়েছিস সব তোরা হ্যাঁ দায়িত্ব নিয়ে সব বেছে দিচ্ছে
কোথাও তো সেটাও বলিস নি যে বলেছিস
page 116 this is the only if you logically consider
What?
that the pitch of the argument that is only the consideration before the court below 116 of the paper book your lordship will find
আর নতুন করে
না, 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 না।
argument করলে মুশকিল হয়।
Yes.
আমি কিছু করিনি তুই যেটা বলছিস তার উত্তরটা একটু দিচ্ছি
What?
চেষ্টা করছি
আমি
Yes. What? 116.
that is the only argument which has advanced apart from that there is nothing my lord the judgment which has shown the court of conscience court of conscience means subject to question my lord the court has the glaring on the face of the record there is something is discrepancy only one thing I could
But
have
this is palpable. This is palpable in view of the evidence that it was first read. Obviously, it had to be drafted before it was signed. The signing cannot precede the drafting.
that is the only thing my lord
That date.
I could have understood that any question to that respect is also put forward any objection was raised
You see, in the arguments also they did not.
that is why my lord what is the argument advanced page 116
দরকার নেই।
middle portion
আমাদের এই
The last will, the 23rd March will was not probated.
No.
yes
No, I put a question. They said below that they didn't have the
Yes.
money or anything below to.
Subsequently, also they did not.
মায়েরই থাকে
They have the money to engage you,
No, this is a different thing. That is why they
Could have done in the meantime.
That's exactly why that they have engaged me. If they had the money, would have engaged Mr.
Yes.
Rai.
No,
This is a glaring example.
clearly example will find my lord,
Well,
your lordship kind.
Will request the Chief Justice to assign this matter to the bench of Justice Vasudhan. This question will be answered.
Hey,
This
he can
question
say
will be answered.
anything. But not Mr. Basu. Now, my lord, his son is getting married. Do not disturb him at all. Whenever we go with a civil matter to his lordship,
Whose son is getting married?
Justice Basu's son, Jalpaiguri. Jalpaiguri opening of the
Oh,
court.
it is his second son. No, I hadn't read it serious.
So that has been stalled.
Store?
Not happening.
Not immediately.
ইউটিউবটা বন্ধ কর ইউটিউবটা বন্ধ কর
Yes.
কথা বলে আবার কে
Yes. So
তাহলে আমি বলতাম একটা কথা
যা তো যাওয়া হলো না
আমি তো Yes, I went there to Jalpaiguri to book a matter before Manor Justice Vasu. I went and found that the court will not sit before 11:30. What is the reason? That 4 trucks of iron rod has been stolen last evening, and Manor Justice Vasu is running from pillar to post to get that complaint registered. And your lordship will find
ওপেনিং হবে না
আমি তো তাই তো শুনছি এই তো শুনছি আমি তো জানতাম তো হবে সবাই যাওয়ার জন্য সব টিকিট করে ফেললো
বর্ষার জন্য
and one thing my lord just kindly internal page 3 of the will which is the এখানে খুঁজে পাচ্ছিলাম না তাই জন্য।
yes.
Last 4 lines second page last 4 lines this the entire property of the এই বাড়ি সহ জমি আর মৃত্যুর অন্তে উইল গ্রহীত আমার স্ত্রীর প্রতি বর্তাইবে মানে কালি কনসিডার লাস্ট 4 লাইন
Yes.
এবং উক্ত উইলভুক্ত জায়গায় অবস্থিত ইন্ডিয়ান অয়েল সম্পর্কে অধীন শ্রীপদ সিং ফিলিং স্টেশন নামে পেট্রোল পাম্প চালু আছে আমার মৃত ভাইয়ের ছেলে পার্থ সরকার সহ আমি উইলদাতা শ্রী প্রভাত কুমার সরকার ওই পেট্রোল পাম্প এর অর্ধেক মালিকানায় দখলভোগ করিয়া ব্যবসা চালাইতেছি ওই পেট্রোল পাম্প মৃত্যুর অন্তে আমার সহদলীয় অর্ধাংশ শ্রীমতী শেফালী সরকার অর্ধাংশের মালিক হইবে এবং আমার উক্ত স্ত্রী মৃত্যুর অন্তে ওই অর্ধাংশ আমার উইল গ্রহীতা শ্রী প্রদীপ্ত সরকার মালিক হইবে So the propounder's participation and the entire property has been disposition has been made in favor of the beneficiary is not correct. It is conscious disposition. This is a family business. Mother will still the mother will be there. She will be
The scribe put you into trouble by
not. He has pillar like pillar on the earlier occasion. I said this is too well to protect me or to supply instead of 1L.
overzealous.
27th is a date for assistation. Instead of my lord, he put the signature whatever is. Actually, original will দেখি তো
Oh, what will the original will say? It's a photocopy of the original.
হ্যাঁ কালিটার
কালিটার whether the same ink.
Let us see the original.
Yes,
Din
yes,
থাকবে।
something will might be.
খুলে দিন ওটাকে ছিঁড়বো বসে বসে
বাবা আইডি this opening of the will I was about 7 days in the profession. Mr. Rai was about a year or so. I was assisting my senior Millard before Justice Topon Kumar Dotto, probate matter just after his lordship's elevation. Then my senior said, will take to ante bolo to. So I told the officer they to will. The moment the will came, Millard, I started tearing. Honorable. So after he lordship said, open and Millard,
So
go back 25 years.
I'll tell you another story, but not in
Not here.
some other occasion maybe.
যে অন্য কেউ খেয়ে নিয়েছিল বিলটা
আমি বার করে আপনাকে দিচ্ছি ঠিক কথা signature and the date below it is the same. It's different from the attesting witnesses and the testator's ink. So therefore, do you mean to say that the signature itself was made on 27th of September?
My lord, the date which was put forward, my lord, is subsequent to that, my lord, because at the bottom, my lord, will find.
Look into the will. দিন এটা ওনাকে সাবধানে দেবেন। Therefore, according to your theory, he signed it also on 27th. Signed that, read over and explained. See, the date of signing and the signature ink is same.
Yeah.
Therefore, he signed on 27th September.
এখানে আসলে এইটা কি
Our hunch is that the entire that typewritten portion read over and explained was introduced on that date and he signed on that date. As Mr. Chatterjee was trying to say. That
the
entire thing has been compressed there.
Exactly. Compressed within that.
But she had signed, read over and explained. Scribe's signature, Mr. Chatterjee, itself is not so.
My lord,
Scribe's, even if the scribe did not sign.
because at the
Is there
bottom,
a necessity to-
because the attested on the same day identified that.
yes.
Okay.
Scribe
If
was
it was
overzealous.
subsequently identified, cannot be
If it was a
permissible.
different
It is-
document, my lord, I would not have opened my mouth. But this is a will. Then has to
Scribe,
be a
what turns on
higher
the,
level of evidence is to be there, my lord, because
turns on the
this is,
signature of a scribe.
this is of a human who's not there in this world.
Human signed before the scribe. The human signed, the inhumans also signed, and the scribe,
Then they
who is beyond all the humanity and inhumanity, he
then
signed
he
on.
started doing all.
He
I
grew
think
overwise.
This is respectfully right, mother. There is a problem.
Very well. এটা ঢুকিয়ে দিন খামের মধ্যে। পার্থ থেকে কেড়ে নিন, কেড়ে নিয়ে এটা ঢুকিয়ে।
কেড়ে নিয়ে ঢুকিয়ে দিতে। And
Yes,
one thing, my
sir,
lord,
enough of seeing the into the.
yes, yes.
We have understood what happened. So which will go, that will decide later. The hearing is concluded, judgment is reserved in the matter. Thank you. And Mr. Chakraborty argued very well when you were not there.
That's a very pleasing thing for my lord, me at least.
It's a very risky thing for you also.
No. Never.
Whatever I've learned,
Never. My lord, absolutely not. If
You
the
can never
junior,
be-
my lord, is good, it
You-
is the
A senior is always proud when his
Yes.
junior does well.
absolutely.
Yes.
Then my lord, my senior juniors,
Yes.
they-
Exactly. Just see. Yes.
বাবা, সবাই দেখেছে কিরকম কারোর সময় নেই।
ও তো শুনে আসি
All because of Mr. Rai, my lord, not for me.
there's no one to
কি? Oh.
We are representing the respondent KMD, my lord, led by Mr. Satyajit Talukdar.
Yes.
No, sorry, my lord, on the last occasion, I got delayed because of the rain, my lord.
No difficulty. Ms. Agarwal, you complete quickly because we have heard you enough on the
Yes,
material.
I cannot take much
Now argue the law and get it
Yes.
done.
Only, my lord, two things I would like to show, my lord.
And we'll in any event, in this case, we'll take short written notes of arguments
Yes, my lord.
to for the reference to the pages.
Very well. Now, my lord, lordship, I've shown lot of documents, my lord. I need not repeat. Just I would
That's
like
what-
to show
Written notes.
the deposition.
আজকে শেষ হবে না নোটস দেবে এটা হলদি নামটা yes
My lord, I would just like to show the evidence of the
no you'll do very well
evidence of the defendant. Because I've shown the written statement. Your lordship has seen, my lord, it is just a bare denial, save and except that few sentences are there saying that I have not completed the work. Yes. Now, my lord, kindly take page 206. The deposition starts at 205, my lord.
Lord, may I file my affidavit in opposition to the can, that there was a direction. That was not filed.
what can
My lord,
Can
just that
four. What is that application for
Appropriate orders, my lord.
What was appropriate?
Alleging a violation of an earlier order.
My lord, I shall come to that. Let me complete this.
একটা লাইন লিখে দিন, affidavit in opposition filed today to can 4 of 2022 be kept on record. Yes.
করেছো?
Yes,
Yes.
page 206.
205.
Right.
Yes. Deposition of the second witness, my lord.
Yes.
Lord, then the two lease deeds, my lord, were put given to the witness, but they were marked X and X1 for identification. Subsequently, my lord, on recall, the witness was recalled, my lord, and on re-examination, these two documents were proved. Now, kindly take the cross-examination, my lord. What
So this X and X by 1 was subsequently marked as exhibits.
marked as exhibits?
And X3?
X3.
X is a photocopy, probably.
X
Gazette
is
publication.
Gazette publication. That was not given, my lord. Only
Gazette
30
publication in any event, yes.
Now, my lord, kindly see 206 bottom part.
Yes.
We have not supplied the papers of the land to the plaintiff. I cannot state about the description, position of land at the time of giving possession to the plaintiff. I cannot state about the present position, description, condition of the property, as because I never saw the property. It is true for construction of building sanction plan is required. It is true, it is rightly written in the license deed that after sanction of plan, plaintiff is entitled to make construction on the land. KMDA will not give validity of the building if constructed without any sanction plan. Now, termination notice was issued by KMDA on the ground that within 3 years, as agreed, construction was not done. Kindly. Then we will kindly take the 207 last part. It is true that I have gone through about the documents of this case and aware of facts of this case as per Exhibit 2. Land was decided to be given as per lease. As per the application form stated that land will be granted on, but there are a lot of typographical error, my lord. Granted on lease basis. It is true as per notice plaintiff had filed application form for getting the land on lease basis. It is true that as per Exhibit 3, land was decided to give as per the terms and conditions written in Clause 1 and 2 of Exhibit 3. Exhibit 3, my lord, is the brochure. Then, my lord, it is true Exhibit 4 letter bears the receiving endorsement of KMDA. I cannot state whether KMDA had given any reply to that letter or not. It is not a fact that as KMDA cannot able to execute the deed of lease for the plot of land, plaintiff has to agree for entering agreement for license, subject to authentic conversion of lease document. You know, this is the next lines are very important. As per our process for immediate instruction, not it, immediate implementation. The word should have been immediate implementation.
All right.
As per our process for immediate implementation of project by the lease in initial case, we are executing deed of license with a thought to execute the deed of lease later on. It is not a fact title of the land was not clear at the time of allotment. For that reason, deed of license was executed. So, my lord, it is being deposed that it was a matter of practice adopted by them, though the land was intended to be given to the lease to the parties, but in many cases, my lord, they initially execute the license deed and later on which is converted into the lease deed. And intention was to execute the lease deed, and they denied that the title of the land was not clear to them. Now, this is contrary to what has been contained in the deed of license. Then, my lord, the witness admits that it it is true, I myself is not aware about the conversion, but I heard from senior that initially license deed is executed and later on lease deed is to be executed. There are a lot of typographical error in the typing of the evidence. I'm not aware of the date of completion of acquisition of land, but the process is already completed. I've already filed the document in court showing the fact of completion of acquisition by gazette notification. The acquisition process was done prior to the execution of the document. I cannot state the reason for writing in the license deed that acquisition process is not completed. We have not informed the plaintiff that acquisition process was completed. Then we will kindly take page 209, only last bottom part, paragraph. It is true from the documents exhibit 22 to exhibit 54, it appears that there are correspondence for taking measure for construction of project. It is true, measure has been taken by KMDA for revised site plan. It is shown in exhibit 40 document. And my lord, I'm not showing your lordship all the entirety of the evidence to 110 that they have.
You must have proved the documents.
Let
Otherwise,
us
they
know
would
that
not have been
KMDA had received these letters, but I have no idea regarding these letters and why KMDA did not execute any lease deed or did not issue any reply to these letters.
These are officials. They will only
They say, but they do not say. They
adduce
admit.
evidence on the records and from records.
Then, my lord, kindly come to page 211.
Yes.
Then, my lord, DW2 was recalled, my lord, and was examined. This is an indenture dated 14th October 2004, executed by and between the Governor of West Bengal and KMDA. This is marked as Exhibit A after objection. This is another indenture dated 22nd January 1996, executed by and between the Governor of State of West Bengal and KMDA. This is marked as Exhibit B. The deeds were executed with an object to acquire the schedules of the plot of land.
What was the significance of these documents?
These documents, the significance is, my lord, the case that has been made out by the defendant is this, that the title of the land was always clear. Even prior, when the plots were put into auction, then at that point of time also, the KMDA had the title over the property. In support of such contention, my lord, they had exhibited the two documents.
They showed that they had transfer title and all. We'll come back in. Yes. So, Ms. Agarwal, you say that the evidence is sufficient to show that you had complied with all requirements and everything.
Yes,
So, this allegation was baseless.
yes. This was
This
my
is the
basic
basic point
contention,
and the
basic
evidence
point.
for that.
And then, my lord, that in fact, a public authority, my lord, from very inception,
Yes.
was acting with in an arbitrary manner when, my lord, a lot booklet, brochure, or the property was put into auction with the condition that the lease will be executed.
Yes.
And the real intention between the parties was to execute the lease deed for 99 years.
Right.
99 and 99 years, my lord. And therefore, subsequently, change of the stand by the government authority, my lord, is a public authority, that the title is not clear. For this reason, we are executing the license deed, my lord, goes to show that from very inception, my lord, they had acted in a malafide manner, my lord, arbitrary manner, which a public authority, my lord, is not entitled to do under the administrative law, my lord. They are bound to act fairly and reasonably, because if they had the clear title, my lord, nothing prevented them from executing the lease deed, my lord. Then, my lord, lot of things would have been saved, my lord. Nothing, all this situation would not have arisen. Then, my lord, my situation would have been totally different, my lord, in the matter. That is first and the basic point, my lord, which, my lord, from their document, now at the stage of evidence, my lord, where they have brought these two deeds. And, my lord, I have shown from your lordship, from the evidence, that documents relating to the property were not given to the plaintiff. No documents were given. It is these documents had surfaced, not even with the written statement. It is at the stage of evidence, my lord, that these two lease deeds have surfaced. They had produced. Even if, my lord, these documents, my lord, have been marked as exhibit. The documents are of the date of the year 1996 and 2004. 96 document is much prior to the property was put into auction in the January 2003. So, my lord, they had the clear title, my lord, according to them. I had to go by their contention, my lord, that the KMDA had the clear title. So, my lord, the plea that was being taken in the license deed was with a malafide intention that at some later stage they would be they can cancel the license and to take over possession. My lord, a government authority cannot act in such a manner, my lord. This is one of my points, my lord, which I would show to your lordship. Then secondly, my lord, these are from the evidence, my lord. I would not like to show anything else, because my plaintiff's evidence is just narration of all these documents.
Yes,
So
yes,
I'm not, I would not like to waste your lordship's time in that. Then, my lord, एक मिनट वो दे दीजिए, चुप रहे. Now, my lord, the two issue with regard to the conduct, my lord, when I go to the conduct, my lord, let me first take that point. In 2008, my lord, I've annexed the documents which the other day the newspaper cuttings had been lordship had seen.
Yes.
In 2008, when the KMD had, when the license deed was terminated, my lord, KMD had, my lord, tried to take possession of the plot in question. Then, my lord, that was being resisted. We filed the writ petition, which was being heard. And then after a period of 1 month thereafter, my lord, the order of termination was served after the alleged incidents. That was the first
They have
instance.
taken possession in the meantime.
That point of time, they could not succeed.
Now they have taken possession.
No, my lord, here also there is a issue, my lord, that thereafter, when we were relegated to the suit, the order of injunction was there. And, my lord, then we lost in the suit, my lord. My lord, only I'll just show the order. I have not placed the judgment. Thereafter, my lord, what they have done, my lord, they had In 2021, my lord, this appeal, my lord, had appeared before my lord Justice. The division bench presided over before my lord Justice Tandon. My lord, in fact, appeal was fully ready. The my lord said that you proceed with the hearing of the appeal. You are in possession, and a government authority cannot will not take the possession of the land, even if the order of injunction is there or not. So, my lord, there is an order on the record. Your lordship will find that, in fact, in order to proceed with the matter expeditiously, my lord, we did not press for the application injunction for our stay injunction application, because my lord said that there cannot be a stay of the operation of the order, and you are in possession, so we will hear out the appeal expeditiously. Now, my lord, what has happened, my lord, that in 2000, thereafter, my lord, in between, my lord, the corporation had tried to attach the property because of non-payment of the municipal taxes. We filed the writ petition. Then, my lord, under the entire tax of the property in question, KMDA said we will not pay. We paid and cleared. Up to date, there is a clear payment of tax. My lord, in fact, we paid more than 1.5 crore on account of the municipal taxes, my lord. Now, thereafter, my lord, what has happened, my lord, that on June 2023, kindly take my Ken application.
No, just tell us what happened.
Then
They
what,
broke with bulldozers. They
no,
came and
they tried to take forcible possession.
have they taken
No,
or not?
No, my lord, we mentioned the matter before the honorable court.
Yes,
The
just be short
honorable
on
court
that.
listed
We are
the
just
matter.
asking whether you have been dispossessed.
No,
Don't
then,
give the entire story. Yes.
no, I'm not saying why it is so important, Lord. I'm not, I shall not say.
Yeah.
While the matter was going on, my lord, the court said that you refrain your hand, you cannot take forcible
That you
possession.
said right now.
Then they had tried to take the forcible possession. Then it was submitted by them. It is recorded in the order passed by the Honorable Division, the coordinate bench of this Honorable Court in this appeal, that it was wrongly submitted that they had just gone to inspect the property and they were not taking possession. But, my lord, with the help of bulldozers, my lord, they demolished the entirety of my showroom. And all equipments, furnitures, fixtures, all were demolished, my lord, and they erected the boundary wall. Then this court passed an order of injunction. Despite that, my lord, I have photographs to show. Even despite the fact that this honorable court had passed the order of injunction in presence of the officer of the KMD was present in court and in presence of the learned advocate, on the very next day in the morning of 5th of July, my lord, they had again used the bulldozer. So whatever
Ms.
remained,
Agarwal, we have to be very short. Please
I'm just
touch the point.
yes.
We are
This
asking
is
just a.
application, my lord.
Don't elaborate the entire
I'm
thing. You have
asking
placed
for
your
installation
evidence.
of-
Make your arguments on law now.
Now, my lord, just judgment part, my lord, kindly. Only two judgment
Yes,
not
yes,
even
yes.
seen. Judgment, I'll show only the last part. Page 247, my lord, it starts. But your lordship will come to 266.
Yes, decision with reasons.
Yes. Issue number 1, 2, I'm not taking
1
your
and 2,
lordship.
yes, usual.
It's not important.
Right.
Then, my lord, kindly take the issue numbers 3, 4, and 5.
Please.
The entire prayer of plaint rests on holding a declaration valid by the orders of allotment dated 6th March 2003 and 7th March 2003, which it falls. The entire suit would fail, as well as the order dated 8 January 2008 would follow. After going through the allotment letters dated 6th March 2003 and 7th March 2003, which merely lay down the enumeration of payment liable to be made by the plaintiff, it becomes necessary to refer to the deed of license dated 22nd May 2003. Then, my lord, the paragraphs from the deed of license have been quoted. I am not reading. After going through the contentions of the plaintiff and defendant, it becomes clear that the entire cause of action relies on the deed of license and its essence with regard to time and purpose. While plaintiff alleges his right to enjoy the property on the basis of allotments made through letters dated such and such, at the same time seeks invalidation of the order terminating the license. Defendant states through his evidence and contractual obligation under the deed of license that the plaintiff was bound by the condition of deed of license, which makes construction and completion of the supermarket cum food processing unit within 3 years sine qua non. My lord, I have shown to your lordship the deed of license, my lord. It does not say so. That is sine qua non. In fact, my lord, it gives the authorities concerned to extend the time, and it was subject to the sanction of the plan by the KMC and fulfillment of other statutory obligation. Therefore, my lord, when the time is not the essence of the contract, and my lord, it is being diluted by when the authorities were empowered to extend the time, my lord, then my lord, it cannot be said that the time was the essence of the contract. And these words were not even used in the said paragraph, my lord. Now, my lord, then the court proceeded, further relying on page 4, paragraph 5(8) of the license deed, which necessitates construction of supermarket cum food processing unit. The plaintiff failed to convince the reason of inordinate delay. Application of NOC dated 10th March 2006 to West Bengal Pollution Board, since the conclusion of deed of license in making the construction within time and for the said purpose, whereas the defendant contended that the said land is being used as a godown by the plaintiff in contravention to the contract entered upon. Now, from where the court is getting the same that I was using as a godown, my lord, is not mentioned, my lord. And my lord, only on this, this is the only finding, my lord, your lordship will find. Then, my lord, it is true that the deed of license contains clauses that makes the license operative until registration of the deed of lease on 9 years of license, as well as clause 7(4) of the license deed reiterate that upon completion of the process of acquisition of land in favor of West Bengal government, the latter shall accept the lease of the land. However, the question of the license being operative for either 19 years or being converted into a lease subject to acquisition does not arise at all, as the contract entered into bears clear clause of termination, which has been put into effect. The order dated such and such issued by the KMDA indeed has discrepancies pertaining to the date of assent and dispatch, but the contention contained in the order cannot be disputed, and the same being valid, the plaintiff is a defaulter with regard to the terms of the agreement, where time is the essence of the contract. Keeping in view the socio-economic requirement of any developing area, it can be held that the national resource cannot be subjected to unproductive investment. Thus, the plaintiff's prayer for perpetual injunction to enjoy the property over unaccounted years cannot be upheld under any circumstances. So, my lord, the court has not dealt with any of the documents, nothing, save and except that Pollution Control Board, and on the view the time is the essence of the contract.
From the license deed, Ms. Agarwal, please just once more show us the termination clause.
Yes, that is 7(1).
Page number?
Page number is in the second volume, my lord. License deed. Page 40. Kindly come to me, lord. 44. Clause 7(1). That is the only clause, my lord. Five 3, my lord, if your lordship sees, my lord, does not say that the time is the essence of the contract. But 7(1) is the only clause, my lord, which permits them to terminate the license.
7(7).
7(1).
Acha.
Page 44.
5(7), read with 5(7).
Read with 5(7). My lord, 5(7), my lord, this power has been given to us.
Yes.
Now, subli is 10.
No, that's different. 5(7).
5(7) is different.
Right.
There is no other clause.
Lawful for the authority at any time. So, breach of covenant is a
Breach of covenant is the only clause, my lord.
Yes.
So, my lord, if they at best can argue that there is a breach of contract, 5(3).
And the notice, termination notice also quoted 3, 5(3).
5(3) and 2 other clauses below. Electricity was not taken off, water supply and nuisance. And the order, different clauses are there. 13, 5(13) that I have created nuisance over the property. To make arrangement for water supply as well as.
And you have produced elaborate evidence to show, that you have taken steps.
So, my lord, in fact, the lordship will see
And
That-
clause 5.3 shows you rely on clause 5.3 also to show it's not it does not say that time is the
Time is the essence of the contract. It does not show. In fact, my lord, the brochure, your lordship would see, I had shown to your lordship one of the conditions that in construction was to be commenced within a period of 3 years, and in case of delay, my lord, the authorities were entitled to compensation, my lord.
show us that portion also.
Yes. एक मिनट हम छोड़ देते चुप रह जाए एकदम. Kindly see brochure is at page. I had given the colored Xerox copy to your lordship.
No, the document provided for
Clause 8, my lord. Clause 8 of the brochure, my lord, at page 5.
Page?
Page 5 of part 2. Part 2. And I have given on the other day, my lord, the color brochure also.
yes, that is also
That is there. Close it. Construction on the plot has to be commenced within a period of 3 years from the date of execution of the lease deed, according to the approved plan of KMC, failing which the lottie will be liable for compensation as decided by the authority. And my lord, the letter of allotment.
page 5 এ বলছে compensation হচ্ছে termination হচ্ছে না। কিন্তু 7i বলছে ব্রিচ হলে ইয়ে হবে।
And my lord, and I,
But they never extended the time.
my lord, in fact, there was
No extension of time.
There was no
Because they had the option to allow in writing.
Yes, my lord, they had
That was never done.
That was never done. We did not even nobody. It was not a case. But there are letters galore, my lord, where we have said that you execute the lease deed, and these are the difficulties we are facing in making the construction. And they in fact we sought for no objection, because since our status in the KMC record was a licensee only, so we requested them to give the no objection so that we can have the plan sanctioned. That was not even given, my lord. And my lord, then it was coupled with the status quo orders passed by the court, obstructions being created, site plan being given in the later part of December 2004, my lord. These periods, my lord, in fact, could not have been taken into consideration. And my lord, letter of allotment is of 6 March 2003, my lord. This also, my lord, does not contain any such clause, my lord.
5.3 তে বলা আছে 3 years এর মধ্যে construct করবে in accordance with plans approved এখানে
Letter of allotment, my lord, I have disclosed.
42 তে which in accordance with the plans, sections and specifications as shall be approved by the appropriate authorities. এখানে appropriate authority sanction করছে না, কেএমসি ফেলে রেখে দিয়েছে, যেহেতু কেএমডি লাইসেন্স ডিড দিয়েছে, ওটা তো ওনার নয়, কেএমসি বারবার রিফিউজ করে গেছে। কাজে এই প্ল্যান না হলে 3টা has to be 3 years has to be read with this within 3 years subject to plan. প্ল্যান যদি না পায়, এদের কোনো ফল্ট না থাকে, সেটা কনসিডার করতে হবে। Yes.
And my lord, the letter of allotment, my lord, of 6th of March 2003, my lord. My lord, I had placed before your lordship on the other day, this by way of a supplementary paper book, my lord.
Yes.
It does not contain any such clause. And it contains a clause that it will be converted into the lease deed.
This was subsequent to the license deed?
No, it is prior to.
Prior to.
It is a letter of allotment on the thereafter they had executed the deed of license.
But this culminated in the license deed.
It culminated, and my lord, I had shown the recital part from the license deed that they have clearly admitted that the title was not clear, and for this reason, lease deed could not be executed. So, my lord, they were in a dominating position. They had the papers in their hand, and in fact, we had to, my lord, and they were in advantageous situation because it was their representation which we had accepted that it will be executed, a lease deed will be executed, my lord. We did not have any role to play in the same, my lord, in execution of the deed of license.
Good.
Now, my lord, in this score, these are all my factual submission. Can 4, my lord, though I have not placed extensively the relevant paragraphs in my written notes, I shall point out. And, my lord, I am seeking that the property, now there is an injunction that nobody can deal with the property. They have put their padlock, but an order of injunction is there. I am seeking for restoration of possession also. This is my prayer in that application, my lord. And because that was being taken forcibly. And in fact, my lord, while going through the various, my lord, while I was searching, my lord, I found out, my lord, one of the judgment, my lord, delivered by your lordship, my lord, sitting single. In the case of State of West Bengal, represented by the Secretary Department of Fisheries, and another.
Oh, that
Mr.
bulldozer.
Bansal bulldozer.
That was passed singly, not
Singly.
binding on this court. So don't cite
No, my lord.
any other judge.
No, my lord. Even though it might be passed by your lordship sitting singly, my lord.
Yes.
But, my lord, my lord, the principle that was laid down and by your lordship in that judgment, my lord. In fact, I am told, my lord, that was passed by your lordship in a civil division application, and that order of your lordship has been upheld by the Honorable Supreme Court, my lord. An SLP was filed, my lord, and it has been upheld. So I can cite before your lordship, my lord. Now, my lord, to start with, my lord, I prepared the compilation of the judgment.
নলবন আছে না নলবনে একটা আমার মনে হয় যে নলবনে বুলডোজার নিয়ে দাঁড়িয়ে ছিল সব দেখছি এত বড় হবে না দুটো কপি আছে
কোনটা মার্ক করা আর কি দেখে নিচ্ছি। আমি এখন পড়তে গেলে অসুবিধা হলে
আমি ফেরত দিয়ে দেবো না এটা পুরো কম্পাইলেশন
Yes.
So many judgments.
So many judgments.
What are the
3
propositions?
judgments are, my lord, covered on one issue only.
If Ms. Agarwal, you can please give us the propositions. We just take a
Yes,
note
yes, yes,
beside the judgment so that.
Yes, yes. My lord, the first judgment, CM Binna and another,
Yes.
is, my lord, on the issue whether the document should be, whether the relation between the parties was to be treated as lessee or a licensee, lease or license. What would be the criteria, my lord, to determine a document, my lord? That is basically, my lord.
Yes.
And the contention. And I'm playing reliance on paragraph
8, 9. You have given the paragraphs.
9.
Thank you. Yes.
And this 8, 9, and 12.
The usual
Even-
things, exclusive possession.
Yes, and then the power to interest, power to grant sublease.
Grant
With the
sublease, yes.
So, my
Sublease.
lord, in the present
Control
case,
over the
my lord, we were given exclusive possession. Then an interest is sought to be created. We have been given the power to sublease, the allotment letter, as well as the brochure, and itself, the license deed itself show that ultimate intention was to give the lease only. And it is at the behest of the KMDA that the license deed was executed. Then, my lord, on the same line, my lord, is the serial number 4, 1989, volume 4, SCC 570.
That is also lease license.
Lease license. And, my lord, serial number 5 is also same.
All right.
99-3 SCC 545.
Yes.
And AIR 1959 Supreme Court 1262 was also the same. In fact, my lord, this was being cited by them, my lord.
Yeah,
1959 Supreme Court 1.
That is, Associated Hotels is also on that.
Of India, that on that line.
Same.
Lease and license. Construction of the document, my lord. And in fact, Captain D'Souza judgment, my lord, and associated hotel is the basic judgment, my lord.
Yes.
And Captain B.V. D'Souza has been followed in all the other two judgments.
Right.
Now, my lord, number 6 and 8, my lord, I am relying upon with regard to their conduct, my lord. Of the conduct of the KMDA.
So conduct of state authorities in general has to be on a higher footing on that principle.
Yes, on that principle, as well as, my lord, they cannot act, my lord, because, my lord, in fact, your lordship's observation in
Yes.
the said judgment, my lord, basically I am relying upon. Kindly come, I'm taking your lordship to, that is at page 64. আমারটা কপি দিও। ঠিক আছে। In fact, my lord, the entire judgment, my lord, I found, my lord, your lordship had dealt with. Paragraph 13, my lord, the facts of the case has been narrated. Then, my lord, the opposite party number 1 preferred against the order dated 23rd April 2014, passed in the aforementioned miscellaneous appeal, a revision bearing CO number such and such, a coordinate bench of this court, wide order dated 17 September 2015, allowed the said revisional application, thereby setting aside the order of the additional district judge. Several observations were made by this court in the said order dated 17 September 2015. It was inter alia observed by the learned single judge that the plaintiff was in possession of the suit property and had filed the suit wherein the trial court protected its possession by an order of temporary injunction upon hearing both the parties, directing the opposite party not to disturb the peaceful possession and carriage of business of the plaintiff. But as soon as the said order of the trial court was set aside, the state took action with the help of men and agents to get the premises barricaded so that the plaintiff could not run its business. The learned single judge was of the considered view that the issue of recovery of possession could be taken up in the facts of the case by the plaintiff on an application if submitted before the trial court under the provisions of section 151 CPC. As in the instant case, the plaintiff could not file a separate suit under section 6 of the Specific Relief Act. It was further observed that the said court, by an order dated April 25, 2014, had prima facie observed that the state authorities tried to take possession by encircling the property with police personnel and preventing the petitioner from entering into the premises. It was also observed that there was rival contention of the parties as to them being in respective possession, and the said court had passed an order restraining the state from taking any further step in respect of the subject property till April 13, 2014. The bench of the learned single judge went on to hold it found that a serious issue was involved in the suit, and it was desired that an order of status quo in respect of the suit premises be enforced in terms of the order of that court. Then, my lord, kindly come to paragraph 21, my lord. Then application for restoration of possession was filed. 21, on the other hand, it is submitted on behalf of the opposite party number 1. That the order passed in the first revision being CO number such and such, it was made clear that the opposite party number 1 was entitled to restoration of possession. The learned single judge had all but granted such restoration and only just stopped short of doing so, leaving the said tasks to the trial court upon the opposite party number 1, making an appropriate application. It is further argued by the learned senior advocate appearing for the opposite party number 1 that even if there was no order of injunction restraining the present petitioners from dispossessing the opposite party number 1 on the day of dispossession, the absence of such an injunction did not ipso facto entitle the petitioners to dispossess the opposite party number 1 from the suit property without following due process of law. It is submitted that there could not be conceived any such extreme urgency on the part of the petitioners, which would prompt them to dispossess the opposite party number 1 within a day of the injunction order of the trial court being set aside in appeal, and such action was rightly deprecated by the trial court in the impugned order, consequently directing restoration of possession. Then, my lord, several judgments have been quoted. Then kindly come to paragraph 31. The next argument advanced on behalf of the opposite party number 1 is that clause 3 of the license agreement was itself not tenable in the eye of law. This was because the said clause violated the basic tenet of law in the civilized society, that the state, even in its private transactions and contracts, had to act reasonably and upon lawful and relevant grounds of public interest. The state could not resort to arbitrary and discriminatory action, and administrative action was open to judicial review on the ground of malice in law. Such principle also governed commercial contracts entered into by the state or its instrumentality. The state had to act reasonably and could not be sponsoring arbitrary and malafide action, even in the field of private law and contractual relationships. Then, my lord, in support of the said proposition, the two judgments have been cited. Then, your lordship's finding, upon hearing both sides and considering the material facts, it appears that the state took advantage of the temporary injunction granted by the trial court being set aside in appeal. Within a day from the order of the appellate court, the state proceeded in hot haste to barricade the suit property with men and machines, thereby denying the opposite party number 1 even the minimum opportunity to prefer a challenge to the order of the appellate court. The instrumentalities of the state went so far as to prepare a certificate of possession, which was handed over, thereby trampling whatever rights opposite party number 1 had in the property in dispute. The order of the learned single judge in CO number such and such was speaking one, where the learned single judge specifically observed that the issue of recovery of possession could be taken up in the facts of the case by the plaintiff on an application under section 151 CPC. Although it was observed in the said order that it would be desired that an order of status quo in respect of the suit premises be enforced in terms of that court's order, such observation was followed by setting aside the order of the appellate court and restoring the injunction order passed by the trial court, whereby the trial court had restrained the defendants, their mains, and agents from disturbing the plaintiff company's occupation and lawful action over the suit property till disposal of the suit. This apart, the learned single judge had also granted liberty to the present opposite party number 1 to approach the trial court with an application for restoration of possession. A similar order was passed by a different coordinate bench in CO number 2270 of 2016, which was also affirmed by the Honorable Supreme Court. If read as a whole, the said orders of this court could only indicate that it was the intention of this court that the order of the trial court was to be restored fully. In view of the interim disposition of the opposite party number 1, this court permitted the opposite party number 1 to approach the trial court for restoration of possession and simultaneously protected the opposite party number 1 from further action of the state. It would be absurd to interpret such orders to mean that in the same breath this court granted opposite party number 1 the liberty to seek restoration of possession and to bind it to the status quo as was prevalent after such disposition. As to the argument advanced by the petitioners that the state had exercised its option of termination of the license given to the opposite party number 1 by invoking clause 3 of the relevant agreement, such clause itself is under the scanner in the suit, in view of the very unreasonable and arbitrary nature of the said clause. The state obviously was in a position of advantage when handing over the said agreement and misused such advantage to incorporate the patently partial clause that the state was permitted to terminate the contract on any ground whatsoever, including theoretically any whimsical and arbitrary reason suitable to the state officials. The argument that the amendment challenging the notice of termination was still inchoate does not apply to logic, since the suit in its original form already incorporated a declaration that the plaintiff had every legal right or authority to run business over the property in suit. Implicit within such declaration is a challenge to the notice of termination of license. Even irrespective of a specific challenge to a notice of termination, the court had to incidentally decide the issue as to whether the notice of termination of the plaintiff's right to run business over the property was legally valid. While deciding the plaintiff's entitlement to a declaration of his right to run business, a necessary corollary of such adjudication should be a consideration of the legality of any affront to such right to run business, including the invocation of clause 3 of the relevant agreement. This apart, the notice to terminate the license was issued during pendency of the suit and thus could not be challenged in the original plaint. The effect of such event would be in any event be governed by the result of the suit. What irks judicial conscience most is the high-handed modus operandi adopted by the state in barricading the suit property within a day of the trial court's injunction order being vacated and the extreme urgency demonstrated by the state, which promptness is mostly lacking in various other essential spheres, in shutting out the opposite party number 1 from the suit property. The circumstances indicate unerringly, at least to malice in law, if not malice in fact. Despite the vacating of the injunction order, the state could not in any fact dispossess the opposite party number 1 by barricading the suit property without due process of law. Even a trespasser has to be evicted under Indian law by taking recourse to due process of law. Such unreasonable and arbitrary behavior of the state, which is supposed to be impersonal and rational, gives rise to a presumption of malafide and arbitrary action, which is deplorable under any circumstance. It has been uniformly laid down in the cited decisions that no person can be evicted without due process of law, and that in case of illegal possession, the court's hands are not tied in doing complete justice by directing restoration of possession. Precisely.
Yes, Ms. Agarwal,
Yes, this is the
order
order.
was yes.
And then there is other judgment which I am relying is very famous judgment, my lord, Ramanna Dayaram Shetty, International Airport Authority of India, my lord, but which your lordship has taken care of while dealing with this judgment paragraph. Favorite judgment. My lord, it is with page 80, and with the relevant paragraphs, my lord, are paragraph 11, 12, 24, and 34.
What is 2015 SEC online Cal for?
Yes, my lord, it is, I will not show, my lord, it is because thereafter your lordship's judgment had come. This was the judgment passed by where the trial court was directed to hear the application for restoration of possession.
In the same matter? No.
In the same matter.
Oh, in the same matter.
In the same matter.
So we are putting across. Because in the same matter, this merged into the.
This merged into the same.
What about item number 2 in your?
Item number 2 is very important, my lord.
Yes.
Wellspun Specialty Solutions, my lord, 2022, volume 2, SCC, page 32. My lord, I am relying upon those so many paragraphs have been indicated.
What is the nature of the proposition?
My lord, where it says, my lord, that when can the court gather the time is the essence of the contract on that issue. My lord, kindly come to paragraph 20 and 35. नहीं बस जरूरत को नहीं चुप रहने kindly come to page 15, my lord, paragraph 20.2. I'll not take your lordship's much time, my lord, on this.
Yes.
Time was not the essence of the contract, as the contract provided for extension of time as well as for liquidated damages. Then, my lord, kindly come to paragraph 35. Paragraph 34, rather, my lord, in order to consider the relevancy of time-conditioned obligations, we may observe some basic principles. Subject to the nature of contract, general rule is that promisor is bound to complete the obligations by the date for completion stated in the contract. That is subject to the exception that the promisee is not entitled to liquidated damages if by his act or omissions he has prevented the promisor from completing the work by the completion date. These general principles may be amended by the express terms of the contract as stipulated in this case. Of 35 now, Lord. It is now well settled that whether time is of the essence in a contract has to be culled out from the reading of the entire contract as well as the surrounding circumstances. Merely having an explicit clause may not be sufficient to make time the essence of the contract. As the contract was spread over a long tenure, the intention of the parties to provide for extensions surely reinforces the fact that timely performance was necessary. The fact such extensions were granted indicates ONGC's effort to uphold the integrity of the contract instead of repudiating the same. But here, my lord, prior to the so-called notice, my lord, there is no letter from the authority concerned, my lord, that you are not doing any work or anything. On the contrary, there are letters galore from our part, my lord, where we have requested them to grant NOC, to give the status and to execute the lease deed. The so-called notice was issued for the first time, and my lord, this was given. And in fact, my lord, I have annexed all the documents, my lord, and this license deed, my lord, does not contain the word time is the essence of the contract. And that is not also available in the brochure as well as in the allotment letter. And my lord, in the license deed, it was incorporated that construction has to be made within a period of 3 years, and it can be extended as it required
As per the approved
plan and subject to other
sanctions.
statutory obligations, my lord. My lord, in this context, my lord, construction contract time is not construction contract 12 months ago, 9 that's card कर दिया. My junior is saying one clause, my lord. तू मैंने card कर मुझको बोलना मतलब. And my lord, only one document I would like to show, my lord, from Ken 4, my lord. I'll just indicate.
This was a part of the trial court records.
It was not, but in the application which we have filed, which I am
It
seeking.
was not a part of, because we are hearing the appeal itself.
Ken 4, my lord, your lordship was directed to be heard along with the appeal by
Yes, we are hearing, but we cannot look into documents which are not part.
No, my
What
lord,
is-
I'm not showing any document, my lord, which was available at the time of trial of the suit.
What is this document here?
The document is, my lord, the order passed by the division bench of this honorable court, my lord, and one notice which the KMD had put up at the premises on 29th of June 2023. And the photograph.
What did they say there?
My lord, it was submitted by the learned advocate for the KMDA that they have not taken possession of the property. However, my lord, have noticed, my lord, was put and pasted at the wall of the premises that the KMDA had taken possession. Then, my lord, it
That
is
will be
recorded-
relevant for the purpose of
Restoration.
if you win the appeal, then if you grant restoration,
Yes.
then it will be relevant.
Then it will be relevant. And then, my lord, the order passed by the Honorable Justice Sen, my lord, of 4th of July. That is very relevant, my lord, which records.
Application টা কোথায় আছে? যেটার অপোজিশন আজকে ওনারা ফাইল করলেন। হ্যাঁ হ্যাঁ 4/22 এটাই।
Coming, my lord.
Hmm.
My lord, kindly come to my lord, orders are at from page 329. What I have submitted before your lordship that order passed by the division bench of this honorable court on 4th of February 2000.
Up to Justice Sen's order.
Sen's order. It was Justice Aristotle's order. My lord, kindly come to page 338. 338.
Yes.
My lord, Ken 3 of 2022. This is an application by pending appeal. This matter was taken up on 30th June 2022 in presence of the learned advocate on record of the KMDA. Mrs. Agarwal, learned counsel, appearing on behalf of the appellant on that date, submitted that the respondent has unauthorizedly trespassed into the premises and forcibly taking possession of the shop room. However, learned counsel for the KMDA on that date on instruction submitted that KMDA inspectors had gone to the vicinity and had not taken over the possession of the property in question. The said submission appears to be incorrect factually, as it is now established that the structure was demolished by the KMDA in the meantime. Learned Advocate General, appearing on behalf of the KMDA, has fairly submitted that it was not within his knowledge that any such submission was made earlier. However, relying upon few decisions reported in AR 959 Supreme Court 1262, others, it is submitted that the action of taking over possession by the respondent in the absence of any order of stay from the licensee cannot be said to be unlawful. If these facts were known to us on 30th June 2022, we would have restrained KMDA from demolishing the property. However, keeping in view that the appellant did not pray for stay of operation of the degree as revealed from the order dated 4th February 2021. Milord, the suit was dismissed, Milord, so there could not have been stay of the operation. But we could have prayed for injunction, Milord. But since, Milord, the order of 4th of February 2021 records the appeal was to be taken up expeditiously, Milord, and we were under the apprehension that our position will not be disturbed by KMD, a government authority without due process of law, Milord. And the appeal was not heard immediately. We restrained the KMDA from proceeding any further with demolition. KMDA shall not part with possession of the property in question or encumber the property in any manner whatsoever until further order. Then, Lord, this order was passed on 4th of July 2022. Then, Lord, kindly take one document only, Lord. Lord, from page 41 onwards are the photographs. And my Lord, kindly take just one document at page 344. The land measuring 121.903 kata in plot number C5, premises number 1726, Rajdanga Main Road, Kolkata, Sector 6, has been resumed by KMDA on 29 June 2022 as per direction of the competent authority. Therefore, my Lord, the recording of the court in the order of 4 July 2022, Lordship can find. And just I'll show one photograph. 5th July photograph at page 375. Even after the court had passed the order, my Lord, they had continued with the bulldozer action.
Page?
My Lord, these are all the photographs, but page 375 is one of such photographs. 374, 375.
75 is, yes.
Along with the letter, we had annexed all the photographs were subsequent to the passing of the order. These were annexed to the letter of 12th July. And prior to that also, my Lord, in fact, this news, my Lord, was reported in all the newspapers, my Lord, at the relevant point of time, this action. The photographs of prior date and subsequent to the order being.
Yes.
So, my Lord, this is what I'm praying in Ken 4. Paragraph number 11 number paragraph arbitration, बहुत important. पढ़ दो और 42 जो है arbiter ने किया uphold करे old तो 42.1. My junior is my Lord, she is pointing out in Wellspan's judgment, paragraph 11, my Lord.
Judgment?
Wellspan, really.
Wellspan, yes.
Wellspan speciality, paragraph 11, my Lord. The arbitral tribunal at the outset held that merely having a clause in the contract making time the essence of it would not be determinative. Rather, an overall view having regard to all the terms of contract are to be taken into consideration. Further, they noted that contracts containing provision for extension of time or payment of penalty on default would dilute the obligation of timely performance and renders the clause imbuing time as essence of the
This
contract.
was the arbitral tribunal's finding.
Arbitral tribunal.
But that was affirmed by the Supreme Court.
Supreme Court in paragraph 35. 42.1. 42.1. And in construction contract, time is not essence. Last line. Additionally, the arbitral tribunal also noted that generally under construction contracts, time is not the essence. Ultimately, on this issue, then there are findings.
Para 35, it states as the contract was spread over a long tenure, the intention of the parties to provide for extensions. Ms. Manot, in this case, was there any intention by the parties shown by you to provide extension?
My Lord, with this regard, there is no correspondence, my Lord. my lord, since the process was going on, my lord, and we had taken all the steps, my lord. So, my lord, in fact,
But you had carried over much beyond the period of 3 years.
my lord, we were given possession in uh, uh, May 2000, April 2023. License deed was executed in May 2000. मत बोली point पर मत समझ खराब कर मामला ना मुझे तो आर्गू कर देगी मेरे को खराब मत कर मामला.
No,
May
no.
2023 the license deed was executed, but I have shown to your lordship the documents that order of injunction was there.
No, 1 minute, Ms. Menon. You were given 3 years to complete the construction.
It was not so, my lord. In the license deed it says that
No, 3 years is not even complete today.
no, 3 years is completed.
Not 23. That is
Three.
2003.
3.
While
Yeah.
he said 2020.
3. I
Yeah.
have not said
That is
three. Sorry, but it must have wrongly spelled.
No, no.
My lord,
So you were there in
process-
possession after 2006 also.
my lord, 3, my lord, was commenced within a period of 3 years. That says the brochure that I had to commence. If I do not commence,
Yeah, brochure ultimately culminated in the
license
license
deed.
deed.
License
you have
deed
to go
does
by the
not
license
say
deed.
that the licensee must complete. The word is not there.
No, that will
That
consider.
is not there. That is not there. And that was subject
No,
to.
but they gave you before the termination and the preludes, they gave you 3 years.
Before termination, it is 3 years. I cannot say much.
But the other arguments remain.
Other argument
Yes,
there
yes,
that the
definitely.
plan was given to me only in after the expiry of 1.5 year,
But
in
then this
December 2024.
Wellspun, this observation in Wellspun does not help you.
Yeah, it
because
does not help me. Beloved.
extension
No,
was not
it
sought.
is not. I will not argue.
And it had to be in writing.
Yes.
But the other grounds are
Other grounds
there.
are there.
Yes.
That site plan was there, given in 2024 December.
Yes.
Tax liabilities were cleared later on. And so, my lord, there were status quo orders. All these had prevented me. And all the most, my lord, the KMC plan was not being sanctioned. And construction does not mean, my lord, erection of building. I had done all other groundwork, my lord. Only the building was required to be constructed in accordance with the plan. But rest of the part was completed. So it cannot be said that I have not done any work. What has been stated in the order is that I have not done any work. I have not started the work even. That is in the order. That is in the judgment passed by the trial court. My lord, the finding of the court, my lord, just to formulate, of the authority concerned was that I have not even done the soil testing, and and the preparatory work was not done, and the plan was not prepared, my lord. All these findings have no basis, my lord. I have shown documents in support of such
Well,
contention.
Ms. Agarwal, you will
these
file
are
a
my
brief
submissions.
written notes of arguments on the next date. Yes. Yes. Let us send Mr. Bandhavade. Yes.
Let's start now.
Let's start. We'll continue after recess. So
Mulad, after recess, I have a fixed matter, Mulad.
then somebody else has to start. Mr. Bandhavade, we are hearing this for quite some time. Part hard matters we want to carry over.
Mulad, only today's second half, your lordship may kindly accommodate me, Mulad. I'll start now. I'm starting now.
No, then you start the next day. If you
That was I was proposing, Mulad. I did not indicate because I thought she will
would
complete in
continue.
20 minutes. Yeah.
Heard learned counsel appearing for the appellants. Full stop. On the prayer of learned counsel appearing for the respondents. Respondent KMDA, comma. The matter is adjourned till June 23, 2020. Sorry, June.
July.
Today we are on
We are on
26th. 26th.
Your lordship, this reaches on Thursdays.
No. We'll have it here. Till June 30, 2025. Let it be in the list. If you can't come, then.
And my lord, so far as the bill spun, I'm not relying on the entire judgment. I mean, just if there is an extension clause, then it dilutes, and the time is now. That's all.
Yes,
I'm just saying.
that has been stated, but
part.
in para 35 it has been stated the intention of the parties to have extension was there. That
And
is absent. in your-
42.1 also, my lord. I shall indicate in my notes. But here, that case is not being made out by me, my lord.
ঠিক আছে এইটা না একটা আলাদা ফোল্ডার করে দেবেন এই আর্গুমেন্টস মানে সাইটেশনস গুলো আর আমাদের নোটস পরের দিনের নোটসটা দিয়ে দেবেন আলাদা করে এখন পাঠিয়ে দিবো ওরা শেষ করে নিচ্ছে একটা শেষ আচ্ছা ঠিক ঠিক
Answer to this call.
Chief, I am for one respondent Miller. Board Miller.
yes
Ahmed Milot was arguing that
The appellant was in the midst of his argument.
we'll close his argument. We'll start here if he's not there in a parted matter.
Then do you want to start first? Because I was pro forma.
Nobody is appearing for, I mean, not even not only Mr. Ahmed, nobody is appearing for the appellant.
Recommendation.
come back Milot now 1:50. So
Very well.
2 p.m. Milot
2 p.m. পাস ওভার থাকে এটা প্রপার ম্যাটারটা কল করুন যদি থাকে তাহলে ধরে নেব not today
Not today.
you're appearing
Respondent, not today.
none appears for the appellants at the time of call let the matter stand adjourned for the day
I'm applying for the respondent.
yes
1:15 only.
can't hear you
At 2 p.m.
why can't you start the matter specially fixed at your instance
No, my lord, I mentioned it, my lord. Kindly recall Mr. Saurabh Sen.
Saurabh
Lord,
Sen
appeared on the earlier
is
occasion.
with
He was praying that it to be taken up on the today.
today yes so that's why specially fixed start the matter tell us what is the matter about at least
This is, my lord, with regard to, my lord, my probate application, my lord, allowed.
you probate allowed
Yes.
yes
Now, my lord, challenging the grant of probate, they have filed this.
what is the ground primary ground
My lord, primarily their written statement, if looked into, my lord will find, they say impersonification, my lord, undue influence, and my lord, that the testator has never gone to the, my lord, registry office. So, my lord, these grounds were pleaded. Now, my lord, to this ground, my lord, I say, my lord, no evidence has come forward from their end, and the trial court has, my lord, examined the entire thing. My lord, even, my lord, they say, my lord, the marking of thumb impression by the testator. Now, my lord, previously also trial court, my lord, looks to the trial court's judgment, my lord will find to my lord, erode all suspicions, my lord. In 2003 also, the testator executed a sale deed where he used the thumb impression. So, my lord, to dispel that suspicion, my lord, court has gone into that and said, if he can execute, testator can execute in 2003, then why not in 2004 he can use his thumb impression for the same thing? Because his hands were, my lord, shivering at that age. So, my lord,
where does he get that the hands were shivering
my lord, that was in the deposition case.
whose deposition the
My
at
lord,
your witness
executor. So, my lord, executor is the son. My lord, son has deposed to that. And my lord, daughter.
what was the age of the testator
at that time?
shivering hands shivering
My lord, not that
not that old
that old.
85.
That old, but my lord, in the 70s.
85.
85.
he had some disease some 85
No disease. My lord, he was a law clerk by his profession.
what was his exact age
85.
85 is quite
When
Now,
executing
my
the
lord,
will, there's
no
your-
allegation of disease, nothing. So, my lord, only that at the age the hands were shivering, he used thumb impression before the registry office, and my lord, will was proved to its execution. My lord, compliance of 63 and 68 done. So, my lord, there is no dispute. But now, with regard to the other suspicions surrounding circumstances, no evidence is forthcoming.
only suspicious circumstances LTI
LTI. They
what
say
what was the other suspicious circumstance according to them
impersonification. My lord, he never went to
personification he did not
adduce any evidence. My lord, one allegation in the written statement was made that the father used to live with the daughters, and my lord, the sons, my lord, just 8 months prior to execution of the will, my lord, took the father into the custody. Now, my lord, these things happened.
that does not mean that may be all the more a reason for yes tell Mr. Sen we'll give him 15 minutes 15 half an hour we'll complete the matter today After recess, we'll continue. But tell him that actually. 15 for him, 15 for him, and
There's other grounds also. The will there's
what are the other guys? Now you're speaking. Yes.
thumb impression, what is that given by the thumb impression? Though he's a law clerk, he can sign.
Very well.
There is
Half an
no
hour, half an
embarrassment.
hour, 1 hour. No, seriously.
9 I appear for the appellant, my lord. My lord, may I hand over? Oh, right.
We have given this already.
No, my lord, this is a fresh one,
Fresh one.
my lord.
এটা ফেরত দিন. We are returning the earlier one, otherwise we'll be confused.
No, my lord, date is.
Should we keep both?
No. Date is given in today's family tree, my lord. Date is given right hand side top.
So then we are returning the previous one. Otherwise we'll be confused.
Well.
Which is the right.
My lord, Badal Chandra Noshkar is the testator, my lord. My lord, the left hand side, my lord, will find, my lord. I have stated will number 1 and will number 2.
Right.
My lord, both the wills are dated, my lord, 7th of January 2004. On the same date, my lord, 2 wills have been registered, my lord. One at the DSR 2 Barashat and other at the, my lord, Salt Lake, ADSR Salt Lake. On the same date. My lord, so far as the will number 1 is concerned, my lord, it has been registered. Book number 2, my lord, will number 2. This has been put for probate, my lord. That is, my lord, OS 20 of 2006, FATs, such and such, my lord, from which the appeal, my lord. This is the my lord is hearing FA 55 of 2023. My lord, the other will, my lord, is from Salt Lake. It has not been put to probate, my lord. Although, my lord, the will is on the record and the learned trial judge has considered the same will.
It is marked as an exhibit.
It has not been marked as an exhibit, but learned trial judge has considered the same. My lord, so, and the mother, my lord, Mohini Pala Noshkar, my lord, mother also executed the will, my lord, dated 28th of July 1999. Date is given, my lord. And the
Father and mother were the joint owners.
No.
Mother's deed is earlier.
Mother's deed is earlier. Mother died earlier. From that, my lord, the probate.
If she was not she was the sole owner.
No, to those properties, he had her absolute right.
Her absolute right.
Oh, different properties.
Different properties, my lord. My lord, so far as the mother's will, my lord, against that, my lord, mother's will were refused, my lord. The probate was refused, my lord.
Why is the mother's will coming in? If it's a different
My lord,
property.
I will just thereafter, my lord, I have given the genealogical table.
Probate refused, no challenge.
No, challenge, pending.
That is the other.
Mother. So far as the my lord will now consider.
1 second, Mr. Shen, mother's will was exhibited in this matter.
My lord, it was filed, my lord, in this matter along with an application to get it exhibited, my lord, although there was no exhibit. My lord, thereafter, my lord will consider the genealogical table, my lord. Aurobindo is the elder son. His son is, my lord, Kaushik Noshkar. The next second son is, my lord, the Shukumar, the other son rather, Shukumar Noshkar. His son is the Anup Noshkar. Now, my lord, and the others, my lord, the daughters. Now, my lord will consider the will. My lord, in the will, my lord, mother, father, where the, my lord will see, my lord, the executor. My lord, the executor, Shukumar Noshkar, beneficiary as Aurobindo Noshkar and Shukumar Noshkar. And witness are, witness, Kaushik, it will be Kaushik Noshkar, my lord, Kaushik Noshkar and Anup Noshkar. In the will number 2, my lord, it's Aurobindo Noshkar is the executor, beneficiary is the Kaushik Noshkar and Anup Noshkar, and witness is Shukumar and Aurobindo. Just reverse, my lord, the mother's will, executor is Kaushik Noshkar, beneficiary is Kaushik Noshkar and Anup Noshkar, witness is Shukumar Noshkar and Aurobindo Noshkar. My lord, in the father has decided the will in favor of the sons he has made.
So you say those are reciprocal wills?
Reciprocal beneficiaries, my lord. My lord, will take the paper book now, my lord. My lord, in the mother's will, my lord, which is annexed, my lord, to the paper book also, my lord. That is, my lord.
Probate has been granted, you are challenging that.
Probate has been granted, I am challenging that.
So reciprocal will means it's substantial, justifies the present will.
So far as the reciprocal will, the will, my lord, 3 wills have been made. 3 wills have been made within the persons, my lord. In both in 3
Second
wills,
will we cannot look into because no probate application has been filed.
but
And
second will, my lord, I was humbly submitting, my lord. Here in the evidence, it has come, my lord. Will was so far as the will number 1, it was executed in the residence. Thereafter, my lord, the parties go to the registry office, my lord. They stay from 11 to 4 p.m. That is the evidence. After 4 p.m., my lord, the second will emerges, my lord. Second will in Salt Lake and the other will in Barashat.
second will, what is the, I mean, we have to see whether the execution of the first will, you are indicating suspicious circumstance.
My lord, suspicious circumstances, my lord. My lord will
Then the second will go.
So my lord will consider, my lord, the entire facts, my lord. So far as the facts are concerned, my lord, a person, my lord, of 80 years, 80 to 85 years goes to the registry office, my lord, at 11 a.m., my lord, registers a will. Thereafter goes to another. They have accepted that this was executed by the father also.
You are which group?
The daughters.
My daughters.
You are not given anything in any of the wills.
Any of the wills, my lord, question does not arise. In all wills, my lord, either son is getting, where witness is the grandchildren of through the son, and where the grandchildren are getting, witnesses.
Obviously, he was residing with the sons he gave to the son.
My lord, so far as the residence is concerned, my lord, in the other will, my lord, the mother's will, my lord, court has come to a finding that mother was residing with them, and ultimately, my lord, the court came to a finding they could not prove the execution, and that is why, my lord, in mother's will, the probate application was rejected. But so far as this will is concerned, my lord, trial judge, my lord, only relied that since it is a registered will, so
63, 68 must have been complied with.
But
63 of succession and 68 of
my humble submission is, my lord, the entire evidence, my lord, if gone through as a totality, my lord, the will has not been proved, my lord. My lord will kindly see the, my lord, date of death and the presentation, making of the will. My lord, date of death is, my lord, 11th of December 2004, and the will is made on 7th of January 2004. 1 year gap. In the mother's case, my lord, 28th mother will dated is 20th of July 1999. Death is 18th of September 2000. Within 1 year, the moment, my lord, will consider, my lord, the father and mother gets infirm, my lord. At that time, my lord, the will execute.
There's a cutoff date for being infirm.
My lord, that is my submission.
The day your 84th birthday is celebrated, you become infirm.
No, mother says in his own will, my lord, that within few days father will execute a will in favor of the sons. So I am executing in favor of the grandchildren. But within few days it doesn't happen.
But that will has been, probate has been refused.
Probate has been refused, my lord.
Who has challenged that day? You have challenged.
My lord,
As of today, that probate has been refused.
As of today, that probate has been refused.
Mother, whatever the mother said, that does not govern the father.
No,
Father has his own will also.
Father
will means intention.
Mother says that father will execute the will in favor of the sons. So I am executing my will in favor of the grandchildren.
And he executed 5 years after the demise of the mother.
5 years after the demise of
4 years after the demise of
4 years of the, and
so then he was free from the influence of the mother.
Free from influence of the mother, my lord.
The mother could not have decided when the father will execute his will.
No, that is stated in the will. My lord, entire facts.
She felt that father expressed the intention. Maybe.
No, another, my lord, will consider another point, my lord, that none of the wills were filed. Probate application was filed, my lord. The mother's will, my lord, mother died in 2000. Although there is no limitation, but after the father died, first the father's will is filed for probate, my lord. Thereafter, mother's.
They should have filed the father's will probate before the father died.
No. That cannot be, my lord. I was humbly submitting, my lord. Mother died in 2000.
When was the application present will probate application filed when?
Probate application filed in 2006.
2 years after the demise of father. So within a reasonable period.
No, mother's will was also filed. Mother was, they say.
How does the mother's will come into the picture at all?
But unless the mother's.
Why is it relevant at all?
But because of the fact, my lord, the entire process has been kept within 4 persons. The sons,
Father and mother, the parents love the sons, not the daughters.
but my lord, so far
We
as
cannot infer anything.
no, my lord,
You are married daughters.
my lord, so far, my lord,
You were married before their
and
might have been a consideration. I mean,
that might
it's not my will that I will. My egalitarian approach will
Well, so
seep
far-
into.
so-
It's their will, their property. They decide.
so far as the consideration of my lord, keeping out the daughters, my lord, mother's consideration was different, father's consideration was different.
Might be.
Father,
Father and mother was living together.
no, father or mother was living together so far as the
Father
mother's
and mother both are living together
together.
or shared between you.
And in that appeal, my lord, it has come to a finding. The learned trial judge has come to a finding that parents were looked after by the daughters. That finding, coupled with the fact that the will was not
These are not analogous probate. These are not hard.
well, analogously, it was not hard. My lord.
Whatever finding,
on-
that is not binding on.
Last date, my lord, I was humbly praying, my lord, in view of the peculiar facts and circumstances, my lord, both the matters should be heard
No,
together,
no,
my
no,
lord.
no. The considerations are entirely different. It's a different will by a different person. Maybe husband and wife, but
But
both have their own volition. I mean, and that was executed 5 years before the 4 years before the. In fact, 5 years before the other will. Mother's
was-
will was in 1999.
but was-
Father's will 4 years, 5 years after that.
But probate application was made, my lord, after the father's will regarding father's application, father's probate was made.
That will be Germany in the mother's will.
My
That appeal.
My lord. So
This
far-
appeal, what is the suspicious circumstance? Father died in 2004. I'm sorry, father died in, yes, December 2004. In January 2004, he executed a will.
my lord, so far as
63, 68 complied with, then what remains?
no, my
What is
lord,
the suspicious circumstance?
my lord,
Daughters were deprived. That is that
no, no, no,
only.
that cannot be only suspicious.
Do you know that?
My lord. My lord, so far as the wills are concerned, my lord, 2 wills are executed on the same date in 2 different locations, my lord. One is at Barashat and one is at Salt Lake, my lord. My lord, the evidence says, I will take your lordships to the evidence, my lord. Evidence says that the
We don't know which one is fictitious. Both cannot be fictitious together.
I say, my lord, both are fictitious because my country consideration.
We are twins. You and I are twins. One of us murdered somebody. We are put on the box.
My lord.
It's
My lord.
not sure who killed. One of us had to kill. One of the wills have to be genuine.
So far as the my lord, schedule of the wills are concerned, my lord, both the wills contain similar type of properties, my lord.
See, the other will we cannot look into because that was probate was not even applied for. So that was given a go by.
That was considered by the learned trial judge. Learned trial judge, the reasoning is
Take
that
the microphone a bit closer, miss.
but learned trial judge considered the said will.
Up. Please.
He considered the said will and held that since the will different properties are given to the different properties are given to the
By
grandchildren.
will 1 and will 2, different properties.
Different properties, but that is not the case. That is my one of my suspicious circumstances, my lord. In one day, my lord, at Barat,
Same property was given.
same property, my lord, can look through, my lord. We have gone through the records, my lord.
But how do we infer that this will was which one was the genuine one?
My lord, my consideration, my lord, the daughter said another date regarding a will was executed, but the
So your first contention, Mr. Shen, is let's just jot down. One is that 2 wills by testator on same date,
on same date registered at different
places.
different places.
This is one of the suspicious circumstances. And
Another-
what about the mother's will? You said something.
Mother's will, my lord, mother has stated in the will that father will execute the will in few days, but that was not done. Within few days,
That is not a suspicious circumstance.
but
Does not bind the father.
it does
Mother
not.
said mother was of the opinion.
It does not bind the father. My contention is that my lord will consider the date of execution of the will and date of death. My lord will be within 1 year. So my contention is that unless the parents become infirm, you don't approach them. Or even no approach was made. The entire the wheels so far as the literate person putting thumb impression.
That is the third point. We'll come to that.
Malad. Surprising, both the parents died within 1 year of the execution of the will.
Why is that surprising?
But this is surprising because according to mother,
They should have waited and died later.
According to the mother's will, mother has stated something.
What points are you taking? So you mean to say regarding the mother's will, your point is that mother stated father will execute within a few days, but they waited till the father became infirm and then got it executed.
But so far as the beneficiaries and the beneficiaries played the prominent role by having in a reverse manner.
No, the the next point was you made some other point also in between. We said that is the next point.
The thumb impression put by a literate person without any endorsement, that the will has been read over and explained to him.
All right. And the fourth point next.
Next, prominent role of the beneficiary in a reverse manner, in one
reverse manner comparing between the two wills, but one was never, no probate was asked for.
But so far as the
that prominence was given a go by.
will take the mother's will also, because it is on record, also.
Yes.
Mother's will, the beneficiary and the witness are just reverse in father's will, that has against which the present appeal,
It was a quid pro quo sort of between these people. Quid pro quo in the sense you get that property, I get this property, and I am the executor there, and vice versa.
And furthermore, in 3 of the wills, same advocate, same typist. None of them came before the court to
maybe the same advocate who drafted the mother's will also.
My contention is none of them came before the court, to give evidence. Only the executor, and the propounder gave evidence, so far as the will is concerned,
Same advocate in all 3 wills.
All 3 wills.
Same advocate and
same typist. So far as the I was humbly submitting, if there was so meeting of minds by the parents, regarding the execution of the will that he will give to the sons and the wife will give to the grandsons, the wills ought to have been executed in a
same day.
Or not same, within a gap of few days, that was not done. Furthermore, so far as the mothers will say that the daughters are happily married, although
they are not happily married.
No, mothers will averment, in the mother's will is that daughters are happily married,
but
that stay in their with their husbands.
That's a good reason.
No,
for any person that can be.
Further good reason has been given. Further good reason is that they do not look after us. The so far as the judgment passed, that is also annexed to the paper book. It says that it has been proved that the daughters is to look after the mother.
That is regarding the mother's will. So that does not affect us in this.
So far as the witness is concerned, now I will take your lordships to the witness given by the parties. I will be hinting at there is no specific statement in the will that the matter was read over to the testator before signing. The witness says.
Where do you get that they were literate from other documents?
That is admitted. Admitted, yes.
So explanation given for that?
Explanation given is propounder is saying one thing, the the witness is saying another thing.
What are the two things?
Propounder is saying his hand was shivering for the last 2 years, and the witness says he was fine and wholehearted at the time of execution of the will.
Maybe otherwise healthy, but the hands may be shivering. That's due to various reasons, not necessarily Alzheimer's.
My lord, kindly take the holistic view, my lord. Not only the shivering of hands. My lord, another thing, my lord, this the signature, the LTI was not, my lord, marked as an exhibit. LTI of what not marked as an exhibit, and the will was, my lord, previously marked, my lord, during evidence as marked as X for identification. Suddenly, just before the delivery of the judgment, my lord, an application is made that you mark the will. The contents of that application, my lord, will see, my lord, entire contents is wrong, in as much as it says that Aurobindo came and deposed as witness in the will. But in fact, my lord, the witness in the will was, my lord, Kaushik. My lord, that the trial judge, my lord, upon hearing the parties, my lord, said that let it be marked as exhibit with objection. And the evidence of the witness, from the evidence of the witness, it is clear, my lord, that there is no such evidence that the testator, after signing the will, had instructed or requested the witness to sign the will as a witness to the execution. That statement is also not there.
Request is not necessary under section 63. Both the attesting witnesses have to see the testator sign, and testator has to sign in the
testator with 63.
It's either under his instruction or where is the এই একটু Indian succession একটা দিন না এখানে ক্লিক করলে কি দেখাবে?
টেস্টেটার
হ্যাঁ, এখানে ক্লিক করলে দেখাবে এগুলো, এই স্ট্যাটিউট গুলো স্ক্রিনে দেখাচ্ছে। এখানে ক্লিক করলে কি দেখাবে স্ট্যাটিউট গুলো? লিস্ট, ওখান থেকে লিংক নেই। এটা ওটা করলে ভালো হয়, তাহলে আর এসব কিছু দরকার হবে না। Yes, section 63.
The testator shall sign or shall affix his mark on the will, or it shall be signed by some other persons in the presence.
Here he has signed or put his
presence. The
affix his
signature
mark.
of the mark of this mark of the testator or the signature of the person shall be so placed that it shall appear that it was intended thereby to give effect to the writing of the will. The will shall be tested as attested by two or more witnesses, each of whom shall seen the testator sign or affix his mark or mark to the will, or has been some other person sign the will in the presence and by the direction of the testator.
No, direction of the testator is not on the attesting witness. Either he has to see the testator sign or affix his mark, or somebody else under the direction of the testator. That is something else.
And
here the testator himself has affixed his mark, so no question.
Or shall receive from the testator a personal acknowledgement of his signature or mark.
That does not come in here. He has, they say they have seen.
My lord,
where is the question of request?
My lord, kindly consider the evidence now. And so far as the, my lord, the will,
each of them has to sign in present of the testator. Testator has to be seen to be signed by.
Another point is, my lord, so far as the execute witness number 2, my lord, there is no witness number 2 in the will. Witness number 2 in the will, my lord, there is no evidence that he signed, my lord, after the
need not. One attesting witness is sufficient as per section 68.
No, one witness gave evidence so far as the witness in the will is concerned, my lord. one has to come and give evidence, my lord. So far as two witnesses are concerned, my lord, but so far as the second witness is concerned, it is not stated that he signed the will, my lord. After the executor put his mark, my lord. That
Not
is not
stated where?
in the evidence, my lord. In the evidence of the
Other attesting. Let us see that. PW2 is the attesting witness.
PW2 is
Generally, PW1 is the propounder and PW2 is.
PW, my lord, propounder, my lord, will kindly consider the evidence of the propounder also, my lord, page 59.
PW2 has not been annexed.
PW2 has been annexed.
No, in the index it's not there.
62, my oh, in
No,
no, no, it's 62. Uh, 59 is the, my lord, 59 is the evidence, my lord, so far as the propounder is concerned.
Yes.
The, my lord, in the cross examination, page 60, my lord, the first line, that we are in separate mess. Father says in his will, my lord, the mess is common, but in the evidence it has come that we are in separate mess.
No. Come to the previous page.
My lord.
My father started living with me after the death of my mother. My elder brother Aurobindo resides in the house where I am residing. But we are in separate. Same house. It's about Aurobindo, not father.
No, father says, my lord.
Father started living with me after death of my mother.
My lord.
Elder brother Aurobindo resides in the house where I am residing, but in separate mess.
Father says, my lord, both the sons along with the father are residing in the same mess. That is the.
They are residing in the same house. Separate mess means probably they cook differently.
No, same. He says same mess, not same house. Father says in the will, my lord. Father says in the will they are in separate. They are in the same mess, but in the.
Where is the will?
My lord,
that's in Bengali. What's the translation of mess?
My lord, translation.
What's the translation of mess?
Translation.
You are making a mess of it.
No. So I have gone through the, my lord.
If not you, then your client's father.
My lord, page 160 is the.
160. Where is it stated? They reside together. Where is it stated?
And 175 is the translation.
We won't look into the translation. We want to see the original. Where is it stated they live together? দুই পুত্র অরবিন্দ no that
আমার
is
পুত্রদ্বয় আমাদের
একই বাড়ি exactly তাহারা একই বাড়িতে দুই ভাই রণজিৎ
না
no that is different.
Translation.
Where does it say that Aurobindo and this person Sukumar, yes, Aurobindo and Sukumar reside together?
In the translation, page 170.
No, translation why should you look into? Original is before us.
My two sons. Oh, that is my lord, 51বর্তী পরিবারের সহিত.
Where is that? Show us.
That is page 163 top, my lord. আমার পুত্রদ্বয় তাহাদের স্ত্রী কন্যা লইয়া আমার সহিত
51 বসবাস করে।
51 বসবাস করে।
মানে
that translation has come in joint mess.
No, it's quite good translation. 51 means অন্য.
That is at page 175.
Very well.
Here, my lord, the page 60, my lord, I was placing. My father had put his LTI in the will first, and his name was written through pen of my nephew Kaushik Noshkar. Aurobindo Noshkar is the father of Kaushik. Kaushik and Anup Noshkar had signed on the will after the name of my father was written by Kaushik. The witness Anup Noshkar is my son. He doesn't say that Anup Malad. Oh no, that is in the other evidence. I know that my father had a talk with his advocate about 10 to 15 days prior to the execution of the will. I heard it from my father. The will was presented for registration at 11 a.m. and the registration was completed by 4 p.m. The will was presented for registration by the learned advocate Krishnapado Sarkar. My father was identified by Kaushik at the time of registration of the will. I signed this affidavit. There is a misstatement that my father died in the year 2000. Here, my lord, it says, my lord, the last page my father would write, but his right hand started trembling about 2 years before his death. Stopped going to court, my lord. Next page, my lord, in the year 1997. Thereafter, my lord, PW2, the evidence of Kaushik, the witness, my lord. Badal Chandra Noshkar, next page 63, I'm reading. Badal Chandra Noshkar was my grandfather. He executed a will prior to his death. I was witness to the will. This is the said will, and this is my signature on the will. This will was written as per instruction of my grandfather. It was scribed by the learned advocate Krishnapada Sarkar, since deceased. It was typed by one Amor Ranjan Majumdar, a typist of Barasat Court. The will was read over to my grandfather by his advocate. My grandfather executed the will by putting thumb impression in his presence as per the instruction of the grandfather. My grandfather was quite hale and hearty at the time of execution of the will. He could sign, but due to old age, he executed the will by putting his thumb impression. My cousin brother Anup was a witness to the other witness to the will. I put the signature as an attesting witness as per the instruction of the grandfather. Thereafter, the learned advocate typist of the will signed on the said will. After that, will was taken to Barasat Registry Office. The will was presented for inspection by learned advocate, myself, and my grandfather accompanied me. My grandfather put his LTI in the TI book written in the said office. I identified grandfather in the will and signed as such. This is my signature in the will as identified. This signature is marked Exhibit 2. So, my lord, so far as the exhibit of the LTI of the witness, that LTI of the testator, my lord, that was not marked. When my lord, in the earlier page, when did the earlier attesting witness Anup sign, my lord, that has also not been stated properly. Only that my cousin brother Anup Noshkar was the other witness to the will. Badal Noshkar, here cross-examination. Badal Chandra Noshkar was my parental grandfather. He used to reside with his two sons in the same house, but mess was joint. Here he says mess was joint. At the time of execution of the will, my grandfather was aged about 80 to 85 years. My grandfather was a registered Mohrar of Barasat Court. Anup Noshkar is the son of my uncle Sukumar Noshkar. All the properties involved in the will were owned by my grandfather at the time of execution of the will. I cannot say some of the properties involved in the will were already vested during the lifetime of my father. Not a fact that my grandfather disposed of some of the properties involved in the will in question. At the time of execution, no outsider in the execution of the will except myself. Onup, my father, uncle, learned advocate, and the Mohorarai accompanied my grandfather to the Parashat court. When he handed over the documents to the learned advocate for preparation of the will, my father instructed to prepare my grandfather instructed to prepare the will. I cannot remember the date thereof, but it was a week prior to the execution of the will. The draft was not prepared in my presence. I cannot file the draft deed, nor I can say about its whereabouts. My father, Badal Chandra Noshkar, had 2 sons and 5 daughters. All 5 daughters were married during the lifetime of my grandfather. Nomita is the youngest daughter, not a fact that Nomita was married after the execution of the will. Pathuria Ghata, where my grandfather used to reside, is about 20 to 25 kilometers away from Barasat. There is no endorsement in the will to the effect that my grandfather put the LTI due to shivering of his hands. I cannot say that Badul Babu gave up his job. Thereafter, my lord, page 66, my lord, Mohini Noshkar was my grandfather. It is a fact my grandfather and grandmother executed 2 separate wills in respect of their properties. Both the sons of the beneficiaries are attesting witness to the will in this case. No outsider signed the will as witness. Not a fact. My grandfather and to work as advocate's clerk at the time of execution of the will under the learned advocate Krishnapada Sarkar. My grandfather had no strained relationship with his sons and daughters. However, my lord, in the will, my lord, it is portrayed differently. I cannot say if my grandfather worked as a clerk under advocate Krishnapada Babu. I cannot say for how long prior to the execution of my grandfather had intimacy with Krishnapada Babu. Not a fact. The TI appearing in the will is not that of Badal Noshkar. Not a fact. Will has not been prepared by my father and uncle in our collusion with a view to grab the properties. Not a fact. Thereafter, no, not a fact, not a fact. So far as the witness says there is cordial relationship. It is contrary to the evidence, my lord, in the averments made in the will. Furthermore, my lord, so far as the execution of the will, my lord, it says, my lord, only at the time of execution of the there was no outsider in the execution of the will except myself. Evidence is vacillating, my lord.
So regarding the other attesting witness having signed in presence of the testator, there is no evidence.
No evidence, my lord.
And this this no strained relationship is also stated, which is contrary to the statement
absolutely
in the
contrary.
will.
And the joint mess.
Joint mess he has also explained in his cross-examination. Second sentence he says he used to reside, but the mess was joint. That's not a very crucial factor. And in the main evidence also, the PW1 says same house in separate.
My lord will kindly
that is not a
turn to page 198, my lord.
198.
Yes.
Yes.
We have filed an application for my lord, order 41 rule 27 also, my lord.
Achha.
But that application contains, my lord, this general diary, my lord. The
diary.
My lord, diary was, my lord, in the evidence, in the written statement, my lord, it was specifically stated that the father was residing with the daughter, my lord, and she was taken away for few days, my lord, until death, my lord, they was not allowed to meet. My lord, the diary was made, my lord. My lord will consider, my lord, page 198, my lord. No, sorry, sir, I'm giving the page.
Your order for 27 is also part of the paper book.
No. Diary.
But this was not an evidence in the court below. So how could you put it in the paper book?
No, my lord. No, the
198 was, could not have put it in the paper book.
Malad, 198 is a malad, not a document relating to this. Malad, it has been by mistake. It has been put in. Malad, the so far as that is.
This is Gadi Durghotana Mrityu.
Malad, that is not relevant. Malad, and it was not by some mistake. Malad, it has gone into the paper. Malad, police complaint. Malad, that is at page 38 of the additional evidence. Malad. Order 41 Rule 27 application. We have served upon it.
You filed it 4 days back.
It was
3 days.
It was filed,
2
Malad.
days back.
Malad, it was filed, Malad, earlier by the one of the respondents, Malad. But to avoid all complications, Malad, the appellant has filed, Malad. Actually, the respondent number 4, Malad, adduced evidence, Malad. He filed written statement, Malad. He gave evidence.
No, after the matter is appearing in the list for hearing, we cannot.
Malad, previously there was also another application, Malad. That is, Malad, appearing, Malad. Also,
Nobody's moving that.
That is that one.
Nobody is moving that. After the, it's at the hearing stage, why should we permit?
So far as this application.
What are you wanting to produce
page
now?
38, page 38, Malad, of Can 1.
Yes.
Looking to Can 1.
Can 3.
Can 3. Can 3, Malad.
How can you move another party's application?
Malad, that is the reason, Malad. Page, Malad.
38 of
page
your
41, Malad. Page 38.
Of your application.
Malad.
Yes.
We are the undersigned are the daughters of Sri Badal Chandra Noshkar of Pathuria Ghata village such and such. We have 2 brothers, Aurobindo Noshkar and Sri Shukumar Noshkar. My younger sister Nomita Noshkar used to live with my father together separately. A few days ago, our said 3 elder brothers and nephews took all my articles from the house of my father and assaulted me and my younger sister, and taking our father forcibly confined him in their house. They did not even allow us to see him. But be it known here that my father is about 90 years old at present, and the old age has weakened him. His vision has become blurred. His health and body also is not normal. Under this situation, they have kept him. They have kept him confined in their house and drove my sisters out of the house. Under this situation, we made a complaint to the local police station on 9 January 2004. GD entry is given, Malad. However, even after that, they have been threatening us, all the sisters, in various ways and have created an atmosphere of terror. Hence, sir, it is our earnest request, kindly take step so that our sister Nomita Noshkar can live with our father. Malad, this fact was stated.
The date when he was taken is not given here.
A few days earlier. Malad, date is Malad, January.
When he was taken away is not given. Few days back.
Few days.
This is lodged on 28th and the will is executed in their favor on 7th.
My lord, just few days after the will was executed, my lord, he was taken away. That is the case made out in the written statement, my lord. And this is the evidence, my lord. We made police complaint to that.
If after the will he was taken away, then there is
no.
4th January, 7th January. 4th January is
4th January and 2nd January.
If he executed the will, what is the relevance of this? He executed the will 21 days prior to this, 20 days prior to this.
No, but it is written, my lord, few days earlier they have been taken away, my lord. And that
how is that relevant here?
In the written statement, my lord will consider the written statement also.
No. How is that material for the grant of probate?
My lord knows, my lord, Maposhal drafting, my lord, the few days, my lord, within that month it was done, my lord. Within that month it was done.
Maposhal drafting of diary, of complaint, police complaint.
Everything, my lord, everything.
So
Even
this was done by an advocate.
Most probably, my lord, seeing the writing, my lord.
How is this germane?
But German is that father was, our case was that father was taken away, father was residing with the daughter, one of the daughters, he was taken away. And my lord, thereafter till death, my lord, they were not allowed to see the father, my lord. That is the specific case in the region.
How does that affect the execution of the will?
But just before the execution in the month of January, he was taken away.
He was taken away before the execution of the will.
My lord, that's January.
It is not clear from here when he was taken away.
My lord, in the written statement, we have specifically stated that on the 4th
What is the date given?
4th January.
4th January he was taken away.
In the written statement.
This does not, if he was taken away on 4th January, why did you wait till 28th January?
Well, 9 January, first complaint was made.
Where is that? You were showing something else.
No. Well,
You are showing 28th January.
Page 30, page 38, 39, my lord, will see, my lord, the GD entry of 9 January is given, my lord.
Where?
Page 40, translation copy, my lord.
What is the original?
In the original, it is also stated, my lord.
Show us the original.
Page 38. এই যে 9 জানুয়ারি এই অবস্থায় আমরা স্থানীয় থানায় 9 জানুয়ারি
GD entry number 424 of 2004. So how do you know the date?
We made the GD entry. We made the GD entry. Thereafter, in spite of no action was taken, we gave a further this one on 28th January.
Have you produced anything to show that he was residing with you? Something to show that he was residing there? How many of you married daughters?
5.
5. She was residing at the same time with all of you?
Yes, he was residing with Nomita.
Nomita. But the complaint is made by Shumita, Sarojini, and all the daughters.
All the daughters.
How do they know?
No. Saying that Nomita, the father was staying with Nomita, he was taken away.
What is the other daughter's interest in saying that? In a diary?
What is
peculiar coincidence?
Peculiar coincidence, my lord.
My father is taken away from me, all my other sisters join.
My lord, all the sisters.
And it is lodged 2 days after the father executes the will, registered will. You should have been more careful. Not only Mofassil drafting, but Mofassil legal advice also.
100% more careful.
Mr. Shane, Mofassil advice is often better than Calcutta advice. You know that, all of you know that, who do civil matters. Mofassil advice goes up to the Supreme Court and upheld. And we are trying to find out faults with those. But luckily, we also had some experience in Mofassil things. So all the daughters lodging a complaint that father was taken from one of them. Coincidentally, all of them are deprived from the will, executed 2 days back from the GD entry.
We, the undersigned, are the daughters of Badal Education. Under this situation, we made a complaint to local police station, such as on 9th January. This evidence is there. But at last line will find, hence take steps so that sister Nomita Noshkar can live with our father. That was. When father is taken away, most of the daughters, nowadays, ring up the other daughters, other sisters. Thereafter, a decision is generally taken. That is the basic intuition.
Definitely, she rang up the other daughters.
Definitely, she rang.
But after coming to know of the will,
thereafter, not going singly, entire 5 daughters went to the police station. That is the picture. But here, my lord, order 21, order 41, rule 27 application, my lord, we have annexed the, my lord, the mother's will and the judgment also, my lord.
That is
Because-
irrelevant for this
Because
purpose.
mother's will say, my lord, has come to a finding that the parents were living with the daughter. That has been the case of the in the written statement, my lord. Our case was also like that he was residing with the daughter. She was
Mother's will was exhibited here.
exactly fine, my lord. This
Mother's will was exhibited in this suit.
it is in the records. It is in.
Was it exhibited or not? Then we cannot look into it.
But that's why that is the reason, my lord, we have filed order 41 rule 27.
Oh, you want to put that in us? Show us that portion of the mother's will.
No, mother's will, no, my lord, the judgment passed in the mother's will. That is under challenge, already pending challenge. my lord.
Judgment, what shall you get from the
Judgment, there is a, this is also in the paper book also. My lord, judgment, my lord, in the judgment, there is a finding that the parents were living with the daughter. That is the
judgment findings? We are not concerned with judgment findings. We want to see if it's the will which you are producing, that is all.
will says
Whatever has been observed in a judgment of the probate court in a different matter is not germane at all here.
so far as this matter is, since the, my lord, the
If you had produced the will as additional evidence, we could have understood the mother's will. That has not been produced.
here, my lord, we have given that. my lord.
Reference in a judgment of
No,
a
mother's will, my lord, doesn't help us because mother has stated that the daughters are living happily with their husbands. But the evidence that has come out and the finding in that probate application is that, my lord, their daughters are living.
Mr. Sen, that judgment is neither binding on us nor binding on anybody. Insofar as this way. So we won't look into that.
Parents are living with the daughters. That is the finding. my lord.
Maybe.
That is the reason, my lord.
Finding of the judge in a different probate court, no. Forget that. Anything else?
No, that was sought to be exhibited, my lord, in the trial court, my lord. That is there, my lord. That judgment is also there.
Judgment, we are not concerned with the judgment.
But my lord, judgment, my lord, it was placed before the learned trial judge. That is the reason we have given, my lord. The learned trial.
Yes, understood. Next.
My lord. Thereafter, my lord, I will place the findings of the learned trial. My lord, page 100. Page 101, my lord. In reference to page 101, as such, there is nothing there, my lord. Page learned advocate for the opposite, page 103, my lord, I am reading. Learned advocate for the opposite party submitted that the testator has executed two wills, one in favor of the petitioners, which is the subject matter in the list, and the another will in favor of the attesting witness of the present will, wherein the petitioners are the witness. As such, there is sufficient materials to raise suspicion regarding.
You are reading page 101?
103.
Sorry. Yes, gone through the wills. Yes, please continue, we'll catch up.
Second paragraph.
Yes,
We have gone through the wills, both dated 7th day of January 2004. Both wills are registered. And
these are wills 1 and 2 of the father.
1 and 2 of the father. Both wills are registered and categorically explained as to why no property has been bequeathed in favor of the respondent and why two separate wills has been executed by deceased Badal Chandra Noshkar.
You say these different properties finding is wrong.
This finding is wrong.
Where are the wills? Let us see the properties.
We don't have the will. We have got from the records.
Not exhibited.
This second will not exhibited, but a certified copy is filed. And learned trial judge has considered that. Even the last will, the main will was not exhibited till the last day. Malad will see the records.
But ultimately, it was exhibited.
Ultimately, it was exhibited, Malad, upon objection. But till the last day, Malad, it was marked for X for identification.
You had produced it, it was on record. And before the judgment, it has been marked.
Before the judgment, it was marked.
Not that you did not have any access to it, it was marked as X for identification.
So far as the CD, the compact disc, that has not come, Malad.
CD?
See, there is tin box, my lord. The CD of this will has come. the will number 6, that is the registered at the Salt Lake office. But so far as the will CD of the will in the Barashat, that has not.
If it is not an exhibit, Mr. Shen, we cannot look into it. Nor could the trial court.
No, my lord,
It was your allegation of suspicious circumstance. You should have approved the will.
my lord, we didn't know know the will. We got it, my lord. We had set a different date, but that date, my lord,
Who pointed it out before the trial court?
they filed.
They filed both the wills.
They filed. We could not get it.
He is nodding his head. He's saying no, he did not file.
No, that is in filed by their
From the
Philistine.
registry office, my lord, DW2 was called. My lord, they called DW2. My lord, he brought those volumes as per my lord the witness. Thereafter, they did not. They said that we don't want anymore, and the deposition ends there. It was brought by DW2. My lord, kindly see DW2. Subject to correction by my lord senior friend. My lord. There is a DW2. My lord will find that page. DW2.
No, 70. Where is DW? Only DW1. No DW2.
No.
Only one DW.
DW2 evidence was struck off because it was incomplete.
Yes, it was struck off. He brought it.
No,
And it
no.
was their evidence, my lord, they sought.
No. So far as our deed is concerned, my lord, so far as the deed given by them, that is in Philistine, that is where Philistine is appearing, my lord. It is in the record. They filed that date. We didn't have any clue regarding that date or another deed has been executed. It is they who filed, my lord, by way of Philistine.
You check from the Philistine. Law court record din onake. Trial court.
There is in record. There is. I've checked up. OPW2 is recorded.
That has been expunged.
So they did. They wished he brought me lord this CD volume of.
So is it in your Philistine also? Let us see that.
I don't know. OPW2 টা OPW2 তো OPW2
Court says that you, Mr. Shen, your client had submitted that the testator has executed 2 separate wills. Oh no, that is the yes. Page 103, the first paragraph.
না ফিস না OPW2 টা কর
আমাদের বলা হয়েছিল 2700
আগের দিন রেকর্ডটা চেক আপ কর
যে পরিষ্কার ভাবে বলা আছে যে ওরা এই ফাইল করবে
I take out my lord OPW.
Yes, Mr. Shen, let us continue with the judgment.
That is the Philistine. এটা দি লাগি দে
The ফিরতিটা লাগে এটা তো 341 টা তো
হ্যাঁ 341 The allegation of suspicious circumstances should be judged in the background of voluntariness if the will, after taking into account the evidence on record, is found to be voluntary. That is, the testator or the executors executed the same voluntarily in exercise of his or her free will. The plea of suspicious circumstances loses its importance. The voluntary character of the will, once proved, outweighs every other allegations. Of course, the court is determining the voluntariness of the will. Voluntary character of the will would be required to scan all apparent suspicious circumstances, though not necessarily as spurious circumstances, but as relevant, including as to so as to come to a conclusion whether under the ordinary circumstances the testatrix would have done it, especially he or she has to inform the old or infirm. Rabindranath Mukherjee versus such and such. Honorable Apex Court has held that the circumstances deviate from natural heirs should not raise any suspicion because the whole idea behind the execution of the will is to interfere with the normal line of succession. It is quite normal that the testator or testatrix to depart the normal heirs, or at least some of them. In some cases, they fully depart, in other only partially. There is nothing unnatural in it. Rather, it is a common phenomenon. The court should never overplay the circumstances, but the decision as to voluntariness of the will
Yes.
should be arrived at.
What is this?
My lord, that
PW2.
OPW2 who brought that CD volume, my lord, is from the registry office.
No, this was the registry office of Barasat.
Yes, but my lord, kindly see 006. Book volume CD 006.
But the other will was executed in Salt Lake. Vidhannagar, different.
My lord, he produced this one, my lord, that is from the record. Otherwise, my lord, that
এটা ফেরত দিন আমি রেখে দিন রেকর্ড দিস ইজ দ্য প্রেজেন্ট উইল
But the other thing, the Firisti malad we have handed over.
ফিরিস্তি ফ্রম দ্য ফিরিস্তি
and ma'am mark করে
ফিরিস্তিটা কি ফিরিস্তি ডাজ নট শো দ্যাট ইউ ফাইলড
No, he filed.
ফিরিস্তি, my lord, kindly
মার্ক করাটা দিন
41 page.
দরখাস্ত করেনি তো
না।
দরখাস্ত করেনি।
হ্যাঁ, কিন্তু লিস্ট অফ এক্সিবিটে it was never exhibited.
দরখাস্ত করেনি মানে in my humble submission it will be the applicant itself. Page 87, my lord, already there is an averment to that effect. Oh,
এটা হলো 6 নাম্বার দলিলটার ফাইটিং এর
না 006 বিধান নাও যে তোমার ইয়ে অনুযায়ী পেজ 20 বিধাননগর সল্টলেক 006 copies of book number 3.
there are only two firistis neither contain any other will original copy of death certificate and
Yes.
this
Lord, exhibit only 3. They produce a power of attorney, we produce this. I mean, Lord, kindly takes up page 28 of the paper book. That is his written statement, on virtue of which Bidhannagar issue came up. Lord, there, my lord, will find the reference of book volume number. Page 28, written from paragraph L.
yes
No, we gave a wrong,
Bidhannagar
wrong
Salt Lake
date,
book
my lord.
volume
We were
number
not-
3, bearing number 6.
yes
But the date
So,
is
my lord,
different.
this,
that the deceased prior to the subsequently
that is typographical most probably. This 7 January হবে. But
you have referred to that
yes.
this is your written statement
My lord, we refer to it different date, my lord. This date was not known to us.
That's the original written statement, a type copy paper. Okay,
My lord, thereafter, my lord, they by Firisti filed that. We didn't have the copy. We did not have the brief copy.
but you don't speak up you speak about another will but there is nobody's case that 17th another will.
That could not be brought. That
So
we
no
failed.
this is your reference
That could
There is no reference by them.
On that date, my lord,
Hmm.
on the dated 17th of March
Nobody's case
2004, my lord, there was no such deed, my lord, although we had stated.
anyway let us continue which page you were you on
Page 104, my lord,
102
104.
4 yes let us continue
Identification by an advocate may be constituted as suspicious circumstances, but in the present case, absence of any allegation that an imposter was identified as statistics so far as this line is concerned, my lord, that is not the case, my lord. We say, my lord, that an imposter was put and the was executed.
Imposter you have not proved at all.
My lord, what evidence has come, I cannot give better evidence. But the case that no, but in the absence of any allegation was there. Our
Allegation, but these are contradictory allegations.
No.
You say that he was coerced by them to execute the will,
No,
and then you say
I say, my lord,
impersonation in the registry office.
yes, my lord. I say, my lord, my case is that, my lord, he was taken away. But so far as the execution of the will or not, we did not have any knowledge. That is the case, my lord. Any circumstances which shows the improbable execution of the will must be clear and cogent, such and such.
You can ask your learned friend to continue with the reading if you want. If your voice is in trouble, and you can highlight the portions. Or you can also continue. We have no trouble in either way.
But thereafter, page 106, my lord.
You have the weekend to recover, so no difficulty. You have the entire weekend to recover your voice.
A will does not require registration, but a registered will carry presumption of genuineness or at least carry more weight. The will is a registered one, and the endorsement by the registrar showing that the testator was in sound disposition of mind and that it was executed out of the testator's free will. It goes a long ways to. Thereafter, my lord, Rabindranath Mukherjee has been quoted, my lord. But in Rabindranath Mukherjee is concerned, my lord, page 106, my lord, I am reading, third paragraph.
Yes.
Rabindranath Mukherjee, my lord, there was an explanation that the were explained by the sub-register to the testatrix. My lord, these endorsement is not there anywhere. Neither, my lord, in the will, my lord, there is any endorsement that any of the witness or any of the advocate read over and explained the contents of
one of the most probably the PW1 said that it was read over and explained.
Said, but I'm saying
that is oral evidence. They can prove by oral evidence.
It is not stated in the will itself. My lord, so far as the
actually, Mr. Sen, this writing in the will in English read over and explained does not mean anything, or in any other language. If I can't read and write, how would I know whether you are writing read over and explained or something else?
No, he
I would say self-defeating proposition basically.
Testator.
It's ridiculous that we lay so much stress on it for so long. I mean, if I don't know how to read and write, Mr. Sen, if you write in a piece of paper, read over, whether you have written read over and explained, how do I know? At the end of the day, it's that document. We say that since it's written in the document, read over and explained, therefore it has been read over and explained.
Right.
Better way to prove is by oral evidence. Someone has to see that it was read over and explained. Writing in a piece of paper, read over and explained, when I can't read and write, does not mean anything.
But so far as the attesting witness did not say so, that it was read over and explained.
The PW1 probably said.
Propounder. And the attesting witness says that only 2 persons were present. Here, he doesn't say the propounder was present.
Did not say.
That is the contrary in evidence.
All right.
When
they will answer that when answering, yes.
Oh, when the witness to the document were interested and the active part was played by a close relation of one of the executors describing himself as unitious in getting the will, was considered as a suspicious circumstances. Well, thereafter, I will come to page 107. Here, in the instant case, petitioner filed a sale deed being such and such through Firisti to show that the previous occasion also the testator executed the sale deed in the same in favor of the third party on 16 December 2003 prior to the execution of the will by putting his LTI. The testator expired on 11th of December 2004, long after the execution of the will. This is also not exhibited. On the ultimate analysis of the legal proposition, it can be said that a registered will. This is the thing that weighed with the learned trial judge, that a registered will does not carry with its presumption of genuineness, but where the court is satisfied that there was no malpractice or fraud in the matter of registration of the will, the court will start with the presumption that the will was executed by the testator knowing the contents of the document. But there but there cannot be any presumption as to his state of health or whether he has the death certificate. The death certificate of the testator has been proved as Exhibit 1, and the will has been exhibited as Exhibit 3 with objection. The will was executed and attested. PW2 is the attesting witness who has affirmed that the Badal Chandra Noshkar has put his thumb impression in all the pages of the will, and he has corroborated the version of PW1. He has also proved his signature on the will as Exhibit 2. PW2 has categorically supported the version of PW1 to the effect that at the time of execution of the will, Badal Chandra Noshkar was physically fit and mentally alert. A lengthy cross-examination of the defendant has only able to surface any element indicate that the will is shrouded with any kind of suspicion. The OP has not produced any corroborative regarding. Thereafter, it was allowed. My contention.
Mr. Shen, regarding your second will being executed on the same date, it's your defense case. But that document was never exhibited, nor was it the case of the propounder. So why should he proceed on that premise? That is one of your grounds, suspicious circumstance.
We have only filed the will to bring it on record, Malak. We did not have any knowledge of that will.
No, your defense case, your written statement states about the will.
That is of different date, Malak. That date was not
But
found.
that is the only will registered in Bidhannagar which is spoken of. They do not rely on any document in their pleading. They do not rely on any other will in their pleading.
But they have filed it. Malak. Firisti is there. That is their document. They have filed.
We couldn't find from the Firisti that they have filed any other will. No, we couldn't file. Page 288 and 304 are the two Firistis as per the index.
The said will was filed by the petitioners through Firisti during hearing of the
So show him that.
কোন উইলটা?
It is the willটার সাথে এটা আনি।
This was the second will or the first will?
But second will, first will, very difficult to say. Which one is the second, which one is first? Both are.
No, this first will was obviously filed. Otherwise, it could not be exhibited.
No, first will, Malaki, that is before the.
So that is, it speaks about only one will. That has to be the first will because it was ultimately exhibited.
No, the judgment speaks of two wills. Both.
In the Firisti, it does not speak of two wills.
No, Firisti, the will in Salt Lake. Firisti will is the Salt Lake will.
Is it mentioned there, Salt Lake?
Yes. Salt Lake.
But since it was not exhibited, we cannot go into that. Anyway, we will ask them. They must have an explanation. But since it was not exhibited and different properties.
No, different, same property. But schedule is also very elaborate. That is also, Malad, they have.
No, are there different properties? Have you seen checked up?
Same properties.
Exactly same.
Here, Malad, the properties are more. Here are few properties. But
Salt Lake fewer properties.
Salt Lake fewer properties.
But Salt Lake was executed later.
Later or previous? How?
Time you say.
Same
11 to 4 there.
11 to 4 there. Thereafter.
Might have gone there before. Anyway, if they don't take any probate, how does it matter?
No. So far as suspicious circumstances, it matters. But the entire facts have to be looked into.
Right.
Then the application calling for the making the exhibit will just go through the application. In the application, in the second page, we don't have a copy.
Is an application for
making the will exhibit on the last date.
How is this material? The will was ultimately executed.
No. Let's see the abundance.
Even if the application is totally wrong.
Application is totally wrong,
Maybe.
So far as the
at the end of the day, the will has been marked as an exhibit.
But the thumb impression has not been marked as an exhibit.
That is a different point. That you have taken.
Thumb impression has not been marked.
Signature to mark.
But not thumb.
LTI could not be marked. Oh, এটা আমি জানতাম। আচ্ছা I didn't know something. My learned brother is saying LTI is not marked as per the CRO. কিন্তু কেউ যদি LTI দেয় তাহলে সেটাতে mark হবে না? কিন্তু LTI তো mark না করলে LTI তো most relevant evidence হতে পারে। ওটা যদি হ্যান্ডরাইটিং এক্সপার্ট চায় বা কিছু চায়, না এটা তো LTI দিলাম, হ্যান্ডরাইটিং এক্সপার্ট চাইলে যে ওটা LTI দিলাম। মার্ক কেন করা যাবে না? ঠিক আছে ঠিক আছে, যখন করে দেখে নেবো।
প্রথম দিকের গুলো
Yes, what else?
only I will make a almost a repetition, my lord. My lord will consider, my lord, parties approaching the court, my lord, the claimants, my lord, approach the court when they approach
Take the microphone a bit closer.
the propounder when they approach the court, my lord, almost simultaneously with the two wills of the mother and the father. But the father's wills was executed, my lord, later, and the mother's will,
Maybe.
my lord. And
How does that make a difference?
no,
They have two wills, they
so far as the two wills and the same date, my lord, if they don't refer, they don't say in the first
If
time.
the will did not come in evidence, you could have also asked for that will to be produced by them, inspection, discovery, whatever.
But that would ought to have been done, my lord. That was not done. But
It is
my lord,
not a part of the records. If
but
it's not exhibited,
my lord, trial judges considered the same.
wrongly,
But trial,
erroneous, entirely, palpably erroneous consideration.
but so far as the probate proceedings are concerned, my lord, the facts in entirety has to be seen into. My lord,
Entirety, but not something which is we cannot in law look into. Something which is not marked, if something is not marked as an exhibit, Mr. Sen, there's a larger ramification. It's not proved in accordance with law. And therefore, the other side does not get an opportunity to cross-examine in accordance with law.
There is admitted document. They are not disputing that this document has not been
No, that does not mean that it will be looked into by the court.
This document has not been there. Only, my lord, yesterday after going through the records, we found that this document. We were hinting out what are the learned trial judges say that.
Yes, don't repeat this argument. What else, Mr. Sen? Conclude your arguments now.
My lord has taken that no endorsement.
We have taken important points which we feel is that LTI by literate person. Second is that your two wills of the same date. Prominent role in reciprocal wills in reverse manner. LTI not marked as exhibit. We will consider that later. And very important, PW2 does not say regarding the other attesting witness. So section 63 is not complied with. Separate mess, we are not laying much stress on that. And one other thing, yes, strained relationship, contrary to the will, they have admitted that PW2 has admitted that relation was good with the daughters. So that takes away the justification given in the will for depriving the daughters. Sons in joint mess, we are not at all accepting your argument. It is not an important argument at all. Same advocate typist in all three wills, maybe. That's the general course of events.
So far as our application, my lord, order 41 rule 27, so far as the police complaint, my lord, is very vital.
What does it prove?
But
there is no pleading to that effect in your written statement.
No, pleading is that if the father was taken away, that pleading is there. That pleading is there.
That he was residing with you.
My
forcibly taken away and diary was lodged.
diary was lost.
Then diary is not there, but he was taken away is there. Date is given. 9th. Let us see from the pleadings. Let us see your pleadings on that.
that in the night of 4th January, the petitioner, along with another brother Aurobindo Nashe, assisted by the sons, came to the hut where the disease decided with the younger daughter and started calling
Page
the
25 D and E.
D and E.
All right.
D and E and could not meet the father till his death on 11th of December.
Why didn't you? This diary was with you. Why, the GD entry was with you. Complaint. Why didn't you produce in the court below? What about order 4127 AA?
Not properly instructed.
This is not so prominent an evidence that we would exercise our power under 4127B.
So far as the evidence is concerned, my lord, whatever the document was, we could get, my lord, was relevant, my lord. We have brought it to before the court, my lord.
It was in your pleading. You did not produce it in the court below.
It was not produced.
Then order 4127 AA is not satisfied.
So far as the documents is concerned, my lord, unless, my lord, the document goes, my lord, we have pleaded, my lord. But
Yeah,
we have-
period. But that it is not such an important document that the court feels that under B that without it we cannot decide the matter. This
it has got relevance in the so far as the
you
case readout of the
Mr. Shen, did you pursue this in a criminal case? You lodged a diary. That does not per se means that the diary, the averments made in the diary was correct. Even if a criminal case was initiated, unless they are convicted, we cannot hold that they actually did it.
But what is
Your lodging a diary is your perception. We cannot proceed on that premise and hold that the will which has been registered, that is a bad will. Not to that extent. B is not invoked, is not to be invoked. Yes, anything else, Mr. Shen? These are all. Yes, Mr. Banerjee or Chatterjee, who? Mr. Chatterjee is more prepared, bro.
I intend to cite some judgments now.
Yes, it's decide right now. That's why you asked you. What else?
Judgment side করতে বলছিলাম না থাকে judgment হ্যাঁ চেক করতে থাকবে
The judgment of this court, my
পরীক্ষা আছে সাড়ে পাঁচ
it is regarding, my lord, the
Yes.
but it's regarding, my lord, the last part, my lord, para 11.
Para 11? Yes. ও ভেঙ্কটাচলা অ্যাঙ্গার
My lord. 1, 2, 3.
এটা সকাল থেকে দেখছি we have been
Again,
looking into
it
this judgment
appears-
since morning.
Well, that is regarding, my lord,
Suspicious circumstance and all.
Citation
Standard of proof like other document, but section 63 has to come in.
Right.
And if there is suspicious circumstance, court of conscience,
Right.
court itself can look into it. And then they have to dispel.
my lord, and thereafter, my lord, 92 Supreme Court, my lord, mere registration does not dispel any doubts.
So you cite them. Formally cite whatever you have to cite, Mr. Shah. We just say that this is, we are taking this judgment.
Right.
This is definitely relevant.
With 1962 Supreme Court.
But you are citing a judgment in which this was quoted. This proposition, no proposition is laid down in this judgment which you are
But
citing.
his judgment latter part, my lord, so far as the LTI is concerned, my lord, it has to why LTI has been given by a literate person, that has to be stated.
Which paragraph?
But judgment of that. LTI का देगा
Yes, yes. Para 12, immediately above para 13.
My lord.
Specific defense of the appellant.
In exhibit A, there has been no.
So before that, specific defense of the appellant, on the other hand, is that testator was illiterate, carries on. No such explanation.
No such explanation.
Very well. Not a single document produced whereupon any signature is available. Here they produced a sale deed that was not exhibited.
In absence of any such document or face of it, a deed admittedly executed by testator 1 year prior to the date of execution of the alleged will find substance. The PW1 stated that he maintained a draft will, but the said was not produced. Here, my lord, he says the draft will, I cannot.
Another deed was sought to be produced by them, where also L2A was put.
That was not exhibited again.
Not exhibited.
Not exhibited. And so far as the other my lord will see the schedule, my lord. Exhaustive schedule. If such schedules are given in wills, my lord, there must be a draft will. That was not produced.
That would be going too far.
No, that is one of the judgments.
Draft deed might have been there, might not have been produced.
Draft deed?
Might have been there was a draft deed. Draft deed is not necessary to be produced.
But it's so far as to dispel the suspicious circumstances.
Just because there's a huge schedule, there will be suspicious circumstance.
Coupled with other facts, my lord. Coupled with other facts, my lord, it becomes
Definitely. Yes.
Yes.
When once suspicion enters into the mind, Mr. Sen, in anything, litigation or otherwise, it finds out various channels to justify that suspicion. That applies to the judgments also.
Well, that is para 17, AIR 1962, Supreme Court, page 567. Mere registration dispels all doubts.
1962.
1962, Supreme Court, page 567.
Sorry, para?
Para 17, man. And 1994, volume 5, SCC, page 135, para 7.
No, so this judgment says mere registration does not necessarily mean.
Dispel all doubts. Here, my lord, the learned trial judge has said, my lord, that since a document is registered and more or less evidence has come, so the other things have been given a go by. That is the overall logic given in the judgment. But
here there are several other circumstances. Sub-registrar himself sent a clerk, came out of the veranda, he was yelling at all this story.
All this story, but here, my lord, neither the parties, neither the witness, nor the sub-registrar, there is no endorsement by the 1995 four Supreme Court cases, my lord, that has been relied by the trial judge. Here, 1995 5 Supreme Para 7, my lord, says that even if there is an endorsement by the registrar, that is not enough. Here there is no endorsement by the registrar, neither by the witness.
Here witness contradicted his earlier statement. That is the first sentence of para 7.
Here, my lord, also there is some contradiction between the statements regarding the witness and the execution.
1995. 4. SCC 455. Para 7.
And so far as 1994, 1995 volume 4 SCC, my lord, page 459, my lord, cited by the taken care by the trial judge, my lord. There is an endorsement by the registrar that the will was read over and explained.
Let us have it first.
Para 6, my lord. That was not here, my lord. He has heavily relied upon this judgment. Done a trial court.
and my lord 2006 volume 13 SCC page 433. My lord, it refers to the my lord, the descriptive schedule and whether
But Mr. Shane, there is a distinction.
Well.
If it's an illiterate person, and there is no explanation as to why it was, as to whether it was read over and explained, then these judgments apply.
so far as
Admittedly, this person was literate. Both of you admit that.
that is the
So there is no question of just because there's an LTI need not be read over and explained. Both of you admit he was literate. Question is, they tried to say that his hands trembled. That's why he put left thumb impression. I remember previously while voting, they take the left thumb impression to do it quickly. My father used to oppose it very vehemently. I mean, why should I? Many people oppose, in
so
fact.
far as the first judgment is
So therefore,
concerned,
there are occasions when educated people, literate people also put left thumb impressions.
but
I mean,
the first judgment says, my lord, in that case, my
why?
lord,
Where is the question? Yes, the other portion remains. But read over and explain, why is it necessary at all? Both of you admit he was literate. It's all on the trembling.
but at least my lord, that is a person's hand is trembling means, my lord, he has some disease.
Old age is not a disease. 85 years old, admittedly, my hands may tremble, sir.
But so far as 2006 volume
After going through some of my own judgments while signing, my hands also tremble. So I'm not yet so old. So hands may tremble.
2006 volume 13.
There are certain horrendous judgments which I write after that while correcting. My hands also tremble. That I'll have to sign this. Hands trembling is a necessary feature of old age. That does not mean it has to be read over and explained to him. He is literate. Both of you admit that.
Then they only say, one of the witness say they read over and explain. That was not required then even.
Superfluous. Forget that.
But 2006 volume 13 SCC matlab page 433. Matlab, this is the para 20 matlab, it speaks of matlab, the comprehensive schedule matlab, the effect of comprehensive schedule.
Read over and explain this judgment to us.
But here
Para 16.
Para 20.
20.
Para 20. But facts were little grave, my lord. More grave, my lord. He was admitted into hospital. There he says executed a deed. So the one of the points that was taken that the deed could not have been, the will could not have been executed with such a great, large, extensive schedules.
Admitted in hospital on an emergency basis, Mr. Shah.
But the schedule is, so far as schedule read with other facts, that's what I was only submitting.
Just because it has a big schedule, he had much property, so big schedule. What's the difficulty in that?
At 2014, volume 15 SCC malach 570 malach para 13 malach. So far as this judgments malach, the overall assessment and cumulative effect of all factors to be considered malach. 2014 volume 15.
Para?
Para 13 malach.
13.
Para 13.
We'll take a short written notes of arguments from you. Just don't annex these judgments again. We are taking these copies. But we'll take a short written so that we don't miss out any point. Para 13. These are general judgments. You need not multiply judgments. Unusual features and suspicious circumstances, definitely that calls for them to prove, dispel that.
Madam, 2023 volume 9 SCC page 734.
For what proposition? Don't repeat judgments on the same proposition just because you have brought.
It's placed on my lord, how a will is to be executed. There it says, my lord, the instruction of the only one 2 paragraphs, my lord.
9 SCC
10.3 B.
page 734.
It is mandatory to get it attested.
Give us copies.
by
Copies.
Josh have copy check.
Mandatory to give copies of judgments to judges.
ঠিক আছে
প্যারাটা কত বললেন?
10.3
10.3.
আরো পিছনে আছে each of the attesting witnesses must have seen the testator sign or affix his mark or the to the will.
Which para? Which para?
Para 10, my lord, para 10.3 C, B and C.
10.3 BC.
BC. Each of the C is each of the attesting witness must have seen the testator sign or affix his mark to the will or has seen other person sign the
This section 63 has been quoted.
63.
Oh, you're citing a judgment for that. Section 63 wasn't it sufficient? This is a quotation of section 63.
Break up wise.
Which of your juniors chose this judgment? I'll impose personal costs.
Another one.
This is the it has been set out section 63.
Most probably, my lord, cited before your lordship's lot of time, my lord, 2021, volume 11, 3 SCC.
How many more judgments, Mr. Sen?
Last.
21.
The more judgments you cite, the more you are at risk of costs. If you lose.
বলছি না তো বলো না সাইটেশনটা বলো
একটা দেখাচ্ছে ব্যাস
You're not finding out the judgment. এত বেশি জাজমেন্ট দিয়ে ফেলেছে আর হারিয়ে গেছে। উইল দিয়ে কিওয়ার্ড দিয়ে সার্চ করেছে বুঝলেন তো যা যা এসছে সব নিয়ে চলে এসছে উইল আর সাসপিশিয়াস সেকেন্ড হোয়াট ওয়ার দ্য কিওয়ার্ডস সার্চ ওয়ার্ডস মিস্টার সেন will and suspicious circumstances whatever you found you brought
no whatever there are many judgments my lord judgments
what about this 2023 what the site
2021 well that is not that
yes
no my lord Lord, I start by saying, Lord, today, my lord, the execution of the will, my lord, probably, my lord, is not in question to the satisfaction of proving it, that it was executed by the testator. Now, my lord, as per
no, 63 is not complied with because the PW2 did not say that the other attesting witness has signed in presence of and all.
63 says, my lord, if my lord takes 63 once, my lord, 63 to be read with 68 together, my lord. Because 63,
both have to be complied with independently.
Yes, yes.
63 and 68.
Yes, yes. Now, my lord, 63.
Not read with business. 63 has to be complied with to the hilt.
To the hilt. Absolutely. My lord, what 63?
C is there. C.
C. The will shall be attested by 2 or more witnesses, each of whom has seen the testator sign. So, my lord, today one of the attesting witness comes to the court and says, I have seen putting him thumb impression in my presence. Complied, my lord?
His part is complied.
Complied. Or,
but each of whom has seen the testator.
So, my lord, the other one
he has to say that the other was at least
says
present.
any one of the attesting witness can come and depose and approve the
Yes,
execution.
but he can come and depose, but the proof will not be restricted to only his seeing the testator, Mr. Chatterjee. There's a restriction. Why 63 has to be read with section 68? 63 has to be complied with. Whoever witness comes, one witness may come, but that witness has to come and to say all these things, whatever is there in C. Testator signed in presence of me, in presence of the other. Both of us saw the testator sign, and all these things.
Yes.
One witness may come, but he should speak for the other witness also. That this has to be complied with. He does not say the other witness.
No, when he says, my lord, at the time of execution, my lord, apart from me, my brother Onup, and my uncle, my lord, nobody was there. This satisfies the condition. At the time of execution, my lord, there is a deposition to that extent. No other outsider.
How does that satisfy?
Now, my lord, if respectfully submitting, my lord,
these people who are outsiders, that's attesting witnesses.
My lord, to the extent of each of whom seeing, affixing the thumb. Now, my lord, one attesting witness comes and says, I have seen.
He signed in my presence.
Signed. And rather in his deposition, rather says, Onup has also assigned as an attestive witness. Now, my lord, this is being deposed. And further goes on to say that, yes, we all were present at the time of execution. may not be that specific.
Let us see that.
My lord, kindly takes up. Takes up page 62 once. My lord, may I read from 63? The third paragraph, Badal Chandra Nashkar. Badal Chandra Nashkar was my grandfather.
This is the relevant paragraph actually. Yes.
Badal Chandra Nashkar was my grandfather. He executed a registered will prior to his death. I was witness of the said will. This is the said will, and this is my signature on the will. This will was written as per the instruction of my grandfather. It was subscribed by the learned advocate Krishnapada Sarkar since deceased. It was typed by one Amor Ranjan Mojumdar, a typist of Barasat Court. The will was read over to my grandfather by his advocate. My grandfather executed the will by putting his thumb impression in my presence, as per the instruction of the grandfather. My grandfather was quite hale and hearty at the time of execution the will. He could sign, but due to old age, he executed the will, putting his thumb impression. My cousin brother, Anup Nashkar, was the other witness to the will. I put my signature as attesting witness as per the instruction of my grandfather. Thereafter, learned advocate and typist of the will signed on the said will. After that, the will was taken to Barasat Registry Office. The will was presented by inspection by learned advocate, myself and my grandfather accompanied me. My grandfather put his LTI in the TI book written by the said office. I identified my grandfather in the will and signed as such. This is my signature in the will as identified. Signature is marked Exhibit 2. Then, my lord, in the cross, Badal Chandra Nashkar was my parental grandfather. He used to reside his two sons in the same house, but Bess was joined. At the time of execution of will, my grandfather was aged about 80-85 years old. My grandfather was a registered Mohra at Barasat Court. Anup Nashkar is the son of my uncle Shukumar Nashkar. All the properties involved in the will were owned by my grandfather at the time of execution of will. I cannot say some of the properties involved in the will were already vested during the lifetime of my grandfather, not a fact that my grandfather deposed some of the properties involved in the will in question. At the time of execution, there was no outsider in the execution except myself, Anup, my father, uncle, learned advocate, and Mohra.
This, even if this satisfied one of the conditions that the testator signed in presence of both the attesting witnesses, but both the attesting witnesses also sign in presence of the testator.
Yes. Now, Milord, one
That has not
attesting
been
witness
stated.
is required to prove the execution.
Forget that.
Two may not come. Milord,
We are not saying two should come. One should come and prove the criteria, the parameters of 63.
Two attesting witness is required.
No. The one attesting witness who comes has to come and satisfy the parameters of 63.
Yes.
63 also says both the testators, both the attesting witnesses have to sign in presence of the testator.
Yes.
They cannot sign the test. Even if the testator signs in their presence, they cannot go to another room and sign.
Absolutely.
No statement on that.
Now, Milord,
regarding his own, he having signed in presence of the testator, at the best we can say that my grandfather, now he says my grandfather executed the will by putting his thumb impression in my presence. And I was witness to the said will. This means that grandfather side testator signed in his presence. My grandfather, he could sign, but due to my cousin brother, I put my signature as an attesting witness. He says as per instruction of my grandfather. Let us take it to be compliance regarding him. Only one thing remains. Anup signed in presence of the testator.
Now, Milord, two lines. Milord, first page 63, the bottom, my cousin brother Anup Nashkar was the other witness. Witness to the will means he is witnessing the will.
Yes, there is no doubt that Anup, from this, that Anup saw the will being executed by the
And
testator.
at the time of this execution, witnessing, Milord,
saw.
Anup was also present.
Anup saw, but where is the statement that Anup signed in presence of the testator?
That statement from the attested, that the other witness,
No,
other attesting witness, Milord, subject to correction, Milord.
No, definitely
Milord,
not.
kindly take
Section 63 has to be complied with to the hilt.
Yes.
Section 68 says one attesting witness can, Mr. Chatterjee, we are speaking to you.
Yes.
Don't disrupt.
Yes.
Section 68 says one attesting witness can come and prove the execution of the will.
Yes.
All the judgments say that execution of the will has to be in terms of section 63. It's an additional requirement.
Yes,
Therefore, even if one attesting witness comes,
yes.
he has to vouch for the other attesting witness. He has to comply with, he has to state all the factors which are stated.
But section 63 in my
One witness will adduce evidence does not mean that the other witnesses paraphernalia are dispensed with.
Milord,
No.
I shall, Milord, satisfy Milord. Section 63, absolutely correct. Compliance of section 63 means, Milord, this criteria has to be present.
Not in respect of one of the
Milord,
attesting
the
witnesses.
evidence part comes. Milord, how to prove that execution?
That is not, there is no doubt on that. One attesting witness has come. Everybody is saying they are
Now,
also.
Milord,
admitted.
Honorable Supreme Court also says, Milord, rely upon those decisions where Honorable Supreme Court says, Milord, if one of the witness comes to the box.
Mr. Chatterjee,
My Lord,
it's you are writing a Guru Rachana. Nobody is asking you that one witness can't come, and who says one witness
Milord,
can't come?
what are the criteria?
You're not understanding our question.
Milord, my
It's
Lord, just
no
tell me.
use speaking with you.
No, Milord,
You're not even understanding what we are saying.
what is falling from, my Lord, if I correctly
What is falling from us? Tell us.
My Lord is asking, my Lord, the evidence which the attesting witness gives, my Lord, is restricted to that Onup has witnessed and at the time of execution, he is present. But
One under section 68, one attesting witness can come and prove the execution of the will.
yes,
Doesn't he have to prove the execution of the will in terms of section 63,
yes,
which includes that both the attesting witnesses had to sign in presence of the testator? Where is the statement in his evidence that Onup signed in presence of the testator? Show us that.
now, my Lord, to that, my Lord, statement.
Everywhere it's stated up to the other conditions, we agree with you. Anup was present, saw execution, that's sufficient. Where is the statement? Only one stray statement that testator signed in presence of the Anup signed in presence of the testator. Where is that statement?
No, my Lord, that specific statement, my Lord, what
statement has to be specific only. How can there be a vague statement?
No, my Lord,
Even no vague statement is there on that.
No, my Lord, no.
Onup, it was executed in presence of Onup. Onup was present at the time of execution. Execution is by the testator. Onup is present then. What does it say? Onup signed in presence of the testator. Nowhere.
Just a second. কোথায় পাচ্ছ তুমি? Sometimes সেটা তো ইয়ে হ্যাঁ সেটা তো ইয়ে
নেই আমি দেখি তিনবার
হলো ইয়ে কৌশিক নট
তিনবার দেখি
কৌশিক নট
ও বলার সময় দেখেছি, ও বলার আগে দেখেছি, মাঝখানে দেখেছি। নাহলে অত কনফিডেন্টলি আমাকে বলতে হবে কোথাও নেই, বার করব।
Milord, may I just take up the record, look into the chief, affidavit in chief?
If there is anything else than this,
Milord, just check up. Affidavit in chief টা বার করো। একটা দেখো ওইটা চিফটা আছে মনে হচ্ছে।
abducted by নমিতা, ছেলেরা বাবাকে চুরি করে নিয়ে গেছে, ওটা নিয়ে কোনো লাভ নেই, কেন ওটা কিছু প্রমাণ হয় না। এই জায়গাটা খুব মুশকিল। বললেই হলো নাকি, কিন্তু ওটা আর সব ঠিক আছে। ওর রেসিপ্রোকাল উইলে প্রমিনেন্ট রোল প্লে করেছে। বাবা যদি ছেলেদেরই শুধু দিয়ে যায়, ছেলেদের মধ্যে ভাগ করে দিই, তাহলে হতে পারে। অন্য উইল, সেকেন্ড উইল যেটা একই দিন এক্সিকিউট করেছে, সেটার এক্সপ্লেনেশন নেই, কিন্তু সেটা তো এক্সিবিটেডও নয় সেই ডকুমেন্টটা, সেটা তো একটা। আর সেটা এ অ্যাডমিট করছে না, এর ডিফেন্সে রয়েছে শুধু। ওর যদি অ্যাডমিটেড না হয়, ইনফ্যাক্ট ট্রায়াল কোর্ট দেখতেও পারতো না ওটা। বাকি সবেতে ঠিক আছে। ট্রেন রিলেশন উইথ ডটার্স বলেছে বটে, সেটা একটা জায়গায় PW2 বলেছে, কিন্তু অ্যাটেস্টিং উইটনেস নাও জানতে পারে ট্রেন রিলেশন ছিল কিনা। ও বলেছে ট্রেন রিলেশন হ্যাঁ এক্স্যাক্টলি অবভিয়াসলি ডিপ্রাইভ করবে, right. It is not there in the paper book.
No, my lord, this language is chief language is not there.
Which is not there?
My lord, the language which is used in the chief, my lord, small double tick. My lord sees, my lord, he says, the testator has marked his, my lord, affixes his, my lord, thumb impression in presence of the witnesses.
What is this?
My lord, this is the chief of Kaushik Sarkar.
The one which you are placing?
Yes.
Where is that portion in the paper book?
My lord, I do not find that statement here.
That is not there at all.
My lord, page 63, top, I have filed my affidavit sometimes ago. I know the contents.
No, this is the affidavit in chief,
Yes.
but he has not corroborated in his oral evidence.
Now, my lord, chief, my lord, knows 18(4) on affidavit, on oath.
Yes.
My lord, that is taken to be true, my lord. That's why on the last portion, generally, even if there is a suggestion not given, court usually
It has been done by me.
Not a fact, not a fact, not a fact.
Affidavit in chief is not even a part of the paper book.
Not even a part of the paper book. That's why, my lord, there is no even cross, if I may put it, the sentence, if not in taken in cross, admitted to be proved. My lord, if he doesn't take this in cross,
Whatever you have stated is in gross. In any, in your chief, you have stated almost nothing.
my lord, but looking at the chief, it's pretty elaborate.
But we require copies of this evidence in chief then. Examination in chief is not a part of the record. Neither yours nor theirs. Why is it not a part of the paper?
Nowadays difficulty is informal paper books are directed.
Informal paper books, affidavit in chief will be there. Department does not.
We don't have the copy, we could not produce.
The informal paper book also we got to done, we used to get it done by the office people, by the
Earlier,
same people. Now you do it yourself.
Informal, take everything.
You have to train your juniors on that. Whose witness is this?
This is my PW2. Attesting witness deposes. Kaushik Noshkar, Kaushik Noshkar.
কিন্তু এটা তো বলছে সামনে প্রেজেন্স অফ উইটনেসেস সই করেছে, এখানেও নেই। Fortunately, this also does not say that it corroborates the same thing. This says that testator executed in presence of witnesses. We have no doubt on that.
The first line of 63 is that testator signing in presence of both.
We are not on the first line. We have told you repeatedly. We are only bothered with Anup not signing in presence of the testator. Only that. That is what we want to see. Eta ferat diye din. Show us something, even a stray sentence that the other attesting witness Anup signed in presence of the testator.
Lord, subject to may I read the line once again? The will shall be attested by 2 or more witnesses, each of whom has seen the testator.
Mr. Chatterjee, you are reading that line before you even entered school.
My lord?
We have been reading that line before you entered school.
Yes.
With due respect. We know what is there. You satisfy yourself.
Yes.
We are sure of that. What is there?
Will, my lord, if I have understood correctly, will shall be attested by 2 or more witnesses, each of the attesting witness.
Read it completely.
Of whom has seen the testator sign. So therefore, each of the attesting witness.
We are not bothered with that after that.
Or affix or has seen some other person not required, in the presence and by the direction of the testator, or has received from the other person acknowledgement of his signature or mark, or the signature of each other person, and each of the witnesses shall sign the will in presence of
Read
the
it
testator.
again,
Yes.
loudly,
And
into
each
the
of
microphone.
witnesses shall sign the will in presence of the testator.
Do you get
But
it now?
Yes. But it shall not be necessary that one of the witnesses.
Forget the
present-
but. Each of the witnesses have to sign in presence of the testator. That is section 63C. Do you get it now?
Yes, yes, yes.
Where is that statement in your evidence? You have been wasting much time on this. You cannot give you, unlimited time on this.
No.
If it's not there, it's not there. Move on to the next point.
Now, my lord, I say, my lord, one witness comes and says execution is there. For the moment, my lord, I say, my lord, 63, this part with regard to the other witness, my lord, there is no straight statement that the other witness who is also an attesting witness,
Yes.
my lord, has signed in presence of the testator. Now, my lord, if that statement is not there, my lord, my respectfully humble submitting, my lord, when, my lord, affixing of thumb impression of the testator has been, my lord, proved to the jolt by the attesting witness, my lord, execution of the will is not in doubt.
You
Now, my lord,
haven't read
yes.
what is there in any of the judgments. We must say that.
Now, my lord, next, my lord, this
Three things. Will, first proposition like any other document. In addition, section 63. These are sine qua non.
Yes.
After 63, can be proved as per 68, which says one attesting witness can come and prove. Prove what? Due execution of the will in terms of what? Section 63.
Yes. Now, my lord, coming to the next point, my lord.
Yes.
The circumstances, my lord, which he says, my lord, in the written statement, my lord.
What about this business of two wills being executed on the same date? One registry office and one Salt Lake registry office and another with a.
Yes, my lord. First, my lord, I have checked up the properties. My lord, the properties, the arc number may be same, but the area are different, entirely different. That's why the learned trial court has come to that finding. Those properties are entirely different.
Area means the portions of the property which are
Yes.
like east west.
No, my lord. Suppose, my lord, I have been given 50 shotok, but my lord, it is looked into that they are given 20 shotok of the same plot.
The total is more than
Total is
70.
more, yes, total is more than 70. So that's why, my lord, the properties are different. And, my lord, court, that's why records, my lord, on looking into it, that the properties are different.
All right.
And, my lord, apart from few properties, there are other properties. Those are absolutely not in the second will also.
All right.
Now, my lord,
LTI by literate person, your oral evidence is there, hands trembling.
hands trembling.
Is there any cross to that counter session?
No. My lord, I respectfully
Check up.
in cross-examination, process nahi.
Page 61, 62 are the statements.
Statement.
And 63 also.
63 also statement. But handing traveling would be PW1's not cross-examination would be there.
No, PW2
But
somewhere
because
stated. Let us find it out.
61,
61 it's there.
it's the only Milord it has come out in cross itself. So therefore, no further cross on that.
Right. And PW2 also states in page 63 somewhere. Let
Yes,
us.
PW2 says that my grandfather is aged. Last page, Milord. 65. There is no endorsement in the will to the effect that my grandfather put his LTI due to swearing of his hand. Let us find 65.
No, that is different. Or something else. Achha. Page 63, he says he could sign, but due to old age, he executed will by putting his thumb impression.
Yes.
Very well.
So, Milord, in cross, Milord, put again, he says
Both of
repeats
things.
the same, Milord. So, Milord, to that, Milord, there is no further question or nothing is coming on record, Milord, today, even in the written statement, that he was suffering from any mental illness and, Milord, he was going to a doctor and, Milord, prescriptions are not coming.
No, those are not there.
Now, my lord, to the other point, my lord, with regard to that fact where they say, my lord, 4th of January, my lord, the one of the sisters' premises, they have taken the father in our custody. And
that we are not much impressed
very good.
because
If my lord is not,
because their bold allegations do not mean anything.
yes,
Even if a criminal case was pending, unless you are convicted, there is no case on.
yes.
We will not rely on
So,
that.
my lord,
The other aspect is LTI
yes.
not marked as exhibit.
Now, my lord, LTI, my lord, in my respectful humble submission, what I have gathered, my lord, generally LTIs are not encircled. My lord, I don't know, my lord, this whether it has been done or not. But my lord, when will is marked as exhibit, because when court is conscious of marking the signature of attesting witness as exhibit, my lord, and thumb impression is looked into.
Here, attesting witnesses' signatures were marked as exhibit.
Yes.
All right.
So, my lord, that may be procedural. My lord, so, my lord, it is nothing, my lord, touching upon the merits of the, my lord, whether the testator has.
They have not actually stated anywhere, subject to correction by Mr. Shen, they have not stated anywhere that this was not the LTI of that person in that sense.
They say impersonification altogether.
Personification, and not only that, they say that he was literate, but his LTI unexplained.
Unexplained.
That may also mean that it's his LTI. But anyway, so LTI there might not have been any, because if 63 is complied, otherwise then it's all right. And prominent role of you people in reciprocal wills.
No, my lord, this, my lord, I find, my lord, today, my lord, grandsons, sons are living with the father. But usually what happens, my lord, the father interacts with the son. So, my lord, this role of son and father as he acting as an attesting witness, then every time the father has to call some friend or third party for his own will. My lord, that is not, my lord, something, my lord, so grave to create a suspicion. My lord, generally in all wills, my lord, either the grandson is there.
And in any event, if by both the wills he wants to give separate portions of his property to the same set of people, so he can have a choice between themselves. Now the other aspect is strained relation. Page 66 PW2 admits relation was good with the daughters,
No,
but the will says strained relation.
I answer this, my lord. My lord, the testator, my lord, a person is a testator, my lord, after his death something is happening. My lord knows, my lord, I cannot speak on the dead man's mind, but the dead man speaks on by writing a will. Now, my lord, even if I say, my lord, when I am in will, my lord, that my grandfather or father, my lord, whoever it is, used to love him. But, my lord, suppose, my lord, the dead man, my lord, during his lifetime has not loved him. And, my lord, has wrote in the documents that I do not love him. My lord, which one to be believed? My lord, this is something, my lord, a person's execution after his death. So there is no direct evidence. My lord, direct evidence, if he has done it in a written form before the registry
So this PW2 was alive at the time when the testator was
my
there.
lord, daughter might come to home, but that doesn't mean, my lord, the father is in love. My lord, it is nowhere stated, my lord, if I read the will, my lord, I have read it over. The anger of the father was, my lord,
They don't look after him, don't come to see him, inquire about him after getting
my
married.
lord, not only that, my lord, after marriage, one of the daughters, my lord, have created a second marriage. So he was unhappy of that. And after that, the daughters, my lord, usually, my lord, is not taking care. My lord, if I put it in a nutshell, if I read the vernacular, my lord, it is very explicit. My lord, it's not that they are in fist and blow. They are coming and fighting with each other. My lord, it's a mental agony which the father was going through for the behavior of the daughter. So even if, my lord, the aunts come to house, and, my lord, the nephew says, yes, aunts come to house, my lord, that doesn't, my lord, change the mind of the father or the mental agony which he was going through for the action of the daughter.
Why was the will exhibited at the last moment?
My lord, to that, my lord, probably, my lord, I have faced a revisional application where evidence were laid on. My lord, at the last moment, it struck to mind of the court and the parties that the will itself has not been marked exhibit.
In connection with the revision?
Yes. My lord, that was allowed, that was technical, it was nobody's case, that is what deliberately hidden, but parties had laid evidence on the will.
And it was marked X for identification also.
So it was a technical error which has gone, my lord, later on cured by the court.
Anything else you want to add?
Now, my lord, one more thing, my lord. Kindly takes up the first appeal for once, my lord, in the paper book. So this is, I find something relevant here.
Where?
Because we are talking of somebody's action, my lord, who is no more in this world.
Yes. What are you trying to show us?
Yes, my lord. Kindly sees the page 115. My lord, 3 daughters have come up.
Hmm.
Third daughter, who has never contested in the court or has never deposed in the court, is now filing a first appeal before this court. So, my lord, why I show these 3 daughters? Only daughter 2 has contested because DW1 is Srimati Sondha Noshkar. My lord, Sondha Noshkar in his written statement says the father was in the custody of Nomita Noshkar. And what happened, my lord, one of the brothers came to the house of Nomita Noshkar and called by her name.
Yes.
So, my lord, it is a personal knowledge of Nomita Noshkar. So, my lord, a personal knowledge of a person, my lord, can be deposed by that person only. My lord, a power of attorney holder or sister cannot depose on personal knowledge. So, my lord, if that story falls flat today, my lord, then father was living with us.
In any event, we are not looking into that
No.
GD entry also.
The cost title, my lord, why I am looking into it, my lord, all daughters are not challenging the will.
Appellant means they are challenged.
No, appellant 3, daughters 5.
All daughters may not challenge.
But, my lord, the case is all the daughters.
All daughters signed that GD, that complaint.
Yes. If I have subject to have 5 daughters have signed, if I am not wrong.
Yes, there were 5.
5 daughters.
There may be various reasons for that.
No. Yes. There are various reasons, but none of the daughters deposed.
Maybe they were not available while filing the appeal.
Yes. Maybe. But none of the daughters deposed. 7 except appellant number 2. And that too, my lord, only something on record, the GD entry, where, my lord, 5 daughters sign, but the knowledge is of only one, and he doesn't depose to the court.
Get your point.
Now, my lord, what are the grounds? This is the first appeal, my lord. My lord, what are the grounds taken in first appeal?
No, whatever they have argued, restrict yourself to that. Need not go through the entire grounds and all this.
No, my lord,
Whatever Mr. Shin has argued,
ground, my lord, is that with regard to that other will, my lord, second will, which my question falls, my lord, though my lord has made his mind, this is not an exhibit not brought by them.
No, even then,
my lord, this is not taken as a ground even in the first appeal.
May not.
So, my lord, even, my lord, assuming, my lord, there is a will, my lord, though not exhibit.
First appeal, fetters of Order 42 Rule 2 are not there.
Yes.
So we can take grounds at any point of time.
Yes. Now, my lord, the second will, my lord,
yes,
shows the thumb impression. If I take the second will on the face value also, my lord, it shows the thumb impression of the grandfather. My lord, the only question is whether the grandfather could travel from one district to the other.
Reason, Mr.
Reason is, my lord, the
why should he run from pillar to
my lord,
post rather from Bidhan Barasat
properties
to
are entirely different. So that's why some properties were given to the grandsons and the
both could be done in Barasat because both covered properties both in Barasat and Bidhannagar.
Now, my lord, to that, my lord, may I just put this question, my lord, today that will, unless, my lord, evidence are on record,
yes,
why it is being done, my lord, I cannot make out a case from this thing. Right. The 7 except I can say, my lord, on record today there is a will, which is not even gone for a probate.
Yes, right. Very well.
So, my lord, to that account, my lord, I only say there is a will. Now, my lord, another question, my lord. That has gone by. Then only one question remains with regard to the section 63, that C part, where my lord, the execution, seeing of the.
Your witnesses, we hope, still alive.
Oh no, yes, he's alive.
Not
He's
who?
The
one who-
the other brother of Onu. He's alive. And my lord, if I may put it in that way, my lord,
Of judgment is 63 mandatory. 63 পুরো 6 ABC হতেই হবে। 63 মাস্ট। একজন এসে একটা সিমটেন্স দিতেই পারে।
ওটা দেখিয়েছি কিন্তু ওই স্পেসিফিক
Mr. Chatterjee, you have gone through that entire affidavit in chief.
I have
Can
to
you get a
go.
copy of that? There may be
yes,
something in there which you are missing out.
Yes, my lord, I've just quickly gone through. My lord, একবার চিফটা দেখে দিন।
You give us copies of, we'll put it as to be mentioned tomorrow. Just give us copies of.
Immediately available আছে। My lord, one thing can be permitted if though it is absolutely
From the court
illegal.
records.
Yes, my lord, we can take a scanned copy photograph in mobile and get it print out. Because this is my chief.
You don't have ownership on that.
We can do it in that. Yes.
We also don't have ownership on our judgments. My judgments. Public property. We can go through, and what we used to do previously, you have to probably do that.
Yes, take down.
Yes.
Both of them filed affidavit.
Whatever, whoever's chief is in your favor, you can take down, and Mr. Shen also same applies to you. Whatever is in your favor, you can have an inspection and take down. Today itself, do it. Tomorrow is a holiday.
Yes, yes. No, now, my lord, we'll do it.
Now, right now, after we rise. Yes. So, any judgment you want to cite?
Yes, my lord, there are.
Your propositions are covered by Mr. Shen's proposition. All the judgments say the same proposition. What is new? Don't waste.
No, I'm not wasting.
So many.
No. I will not cite all because.
In probate matters, unless
We'll count judgments. Whoever cites more judgments loses. Outright.
In probate matters, unless facts prejudice the judges.
Judgment, same. We are tired of these propositions. Probate and matrimonial.
Now, my lord, I say, my lord, only one thing I should add, my lord. Though it's a general proposition, once again.
What?
My lord, in case of execution, there cannot be a mathematical precision. My lord, this is one of the lines which Honorable Supreme Court once again reiterated. My lord, this mathematical precision of this to this, my lord, is something, my lord, struck my mind while I'm reading all the way. My lord, then, my lord, if I read 2014, my lord, 10-14, my lord, I hope, my lord, Mr. Rai has cited this in a previous matter, my lord, as told by Mr. Rai. My lord,
Yes,
if my
all
lord
these
takes a
judgments.
copy of this, my lord, 10-14. 2010-14 Supreme Court cases 266. Kindly takes up
Yes.
paragraph 12 onwards, but I will not read the entire, my lord. These are quoting of provisions. Paragraph 15.
Yes.
From a conjoint reading of the two provisions extracted above, it is evident that a will is required to be attested by two or more witnesses, each of whom has seen the testator signing or affixing his mark on the will, or has seen some other person signing the will in presence, and by the direction of the testator, or has received from the testator personal acknowledgement of the signature or mark or his signature or the signature of such other person, and each of the witnesses signed the will in presence of the testator. Section 68 of the Evidence Act is against the use of a will in evidence unless one attesting witness has been examined to prove the execution. The question, however, is whether the will propounded by the appellant and the purporting to be have been attested by two witnesses, namely Manoj Kumar and Vilas Tike, has been validly proved. But I am skipping over. But after carefully, paragraph 7.
Here also, para 16 stated, what is to be seen is whether examination of the said witness satisfied the requirements of section 63.
Yes. Now, my lord, while examining the section 63, 17, my lord, may I just, after careful analysis of the provision of section 63 would show that proof of execution of a will would require the following aspects to be proved. The testator has signed or affixed his mark to the will, or the will has been signed by some
Four,
other
four.
person.
Mr. Chatterjee, come to
That
four.
each of the witness has signed the will in presence of the testator.
Anup signing in presence of the testator is
Now,
what is troubling us.
Our question to the answer is 19 minute. I am just coming over. Our answer to that question is in affirmative. The deposition of Sri Vilas Tika clearly proves that Pannalal has executed a will in favor of the appellant Gopal Swarup and had signed and affixed his signature in his presence. The trial court and high court have correctly held that will have been signed by the testator in presence of the attesting witnesses. First and the foremost required of the prescribed under section 63. So, my lord, the attesting witness, if he says, my lord, it has been affixed in presence of the witnesses, signing, execution. Well, that is where the execution comes.
It does not stop there, Mr. Chatterjee.
Yes. Now, my lord, paragraph 21, deposition. That brings us to the third requirement, namely that the will must be attested by two or more witnesses, each of whom has seen the testator signing and affixing his marks to the will or has seen some other person signing in the presence and by direction of the testator. The deposition of Sri Vilas TK, in our opinion, satisfies this requirement. Also, in as the witness has in clear and terms stated that not only he, but Sri Manoj, the other as to the will, was also present at the time the testator affixed his signature on the will. So, we'll have same deposition, my lord. He was present at the time of execution of the will. It is noteworthy that the above statement has not been questioned in cross-examination. My lord, very important, my lord. My lord, there is no cross-examination, nothing is coming out from the cross-examination. Or any suggestion made to the effect that while Sri Vilas TK, the witness may have been present. Mr. Manoj was also not so present at the time he was signed by the testator. So there is no suggestion to that given. As a matter of fact, the witness has made categorical statement that Manoj met the testator in court and was taken along, and that not only at the time of signing of the will by the testator, but even before the registrar, Manoj Kumar was present in person. The witness has, while answering a question in process, specifically said Manoj was present. Even at that time, the witnesses signed the will in question.
Para 22, Mr. Chatterjee,
Yes,
why are
sir.
you wasting
On
time?
a careful and a proper reading of the deposition of Sri Vilas TK DW2, we are satisfied the requirement of attestation of the will by two witnesses, each of whom has seen the testator signing or affixing in mark, has been satisfied in the present case. So also the fourth requirement, the attesting witness signed the will in presence of this test formally established. But how it has been established, my lord? Because there is no cross-examination. My lord, today I say
Para 21 and 22 are on different aspects.
it is
Third requirement, 21 is third requirement, 22
yes,
is
yes.
fourth
My
requirement.
lord, but the deposition.
Supreme Court says that has been satisfied by PWT evidence. In your case, it has not been.
Now, my lord, to that, my lord, how on deposition, on cross-examination, he said that the witness was present at the time of.
We have seen the cause, don't repeat.
And my lord, 23
What other judgment? Yes.
Now, my lord,
একটু এড়ে আছে বুঝতে চাই
2010 চোট।
এত বছর বাদে সেকশন 63 পড়াচ্ছে
if direct করলে আর
যে মাইন্ডটা বুঝতে হবে যে মাইন্ডটা একদম বোঝে না যেটা ধরে নিয়েছে সেটাই করবে সব বাকি সব প্রমাণ করেছে হ্যাঁ এক্স্যাক্টলি টেস্টের সামনে পুলিশের সামনে টেস্টের বলছে অনুপের ক্ষেত্রে প্রমাণ সেটাই প্রবলেম বাকি যদি এফিডেভিট ইন চিফ থেকে কিছু পায় এই একটা পয়েন্টই তাহলে গাঁটে আটকে যাচ্ছে
my lord, this, my lord, 1613 SCC page 433. Well, and 2014 10-14 my lord, that mathematical precision of paragraph 23 my lord,
paragraph
23 of the earlier judgment. My lord, that it need not be proved by mathematical precision.
All right. Para 23 is the only paragraph which you should have cited.
No, my lord, my lord, being fair, my lord, what was the deposition? Because it was also troubling, my lord, while I was reading.
We'll consider.
Now
Next,
this
yes.
33 paragraph.
Yes.
Well, at the burden of proof that the will has been validly executed. Maharaj got paragraph 13.
Yes.
13 SCC 430. The burden of proof that the will has been validly executed as genuine document is on the propounder. The propounder is also required to prove that the testator has signed the will and that he had put his signature out of his own free will, having a sound disposition of mind and understood the nature and effect thereof. If the sufficient evidence in this behalf is brought on record, the onus on the propounder may be held to have been discharged. But the onus would be on the applicant to remove the suspicion by leading sufficient and cogent evidence if there exists any. In the case of proof of a will, a signature of a testator alone would not prove the execution thereof, if his mind may appear to be feeble and debilitated. However, if a defense of fraud, coercion, undue influence is raised, the burden would be on the caveator. So, my lord, here I am. My lord, if I have proved the execution and my lord, he was a free mind and my lord, literate. Most importantly, both sides says my lord, he was literate. More fully, my lord, he was a law clerk. He worked in court. He knows what he is doing, what is a will, what is a registry office, and where he is standing. So, my lord, all these factors being there, my lord, and there is no evidence of feeble mind. Execution proved one criteria for the time being not so clearly coming before the court. Now, my lord, this if I discharge this part, my lord, my respectful humble submission, a deadsman wish, if wants to be thrashed out, my lord, then the onus is shifted on the caveator, the allegations which you raise.
Yes. Anything else?
My lord, then I come take a look at the chief and come back.
No other judgment.
My lord, mostly on similar line.
Don't repeat
But I'm
judgments.
not repeating, but this I find these two covers.
Yes,
most
this
of
covers your whatever you are trying to say. Absolutely. And the other propositions are there in Mr. Shen's
I
judgment.
brought that Shema's view, that personal knowledge. Since my lord is not taking that view of Nomita, who has not even deposed. So I'm not citing that personal knowledge cannot be deposed by others. So though I brought that, my lord, another. There is one judgment on thumb impression, if I may cite.
You cite your judgments. Don't hesitate
reputation
in citing your judgments. Nomita, that judgment also cite. For the record, cite your judgments.
No, my lord is not taking that point.
No, but if you change your mind later on, don't take the risk. In court, we are not taking later on, we have a rethink and don't ever take a risk. Particularly in a matter where you have come prepared with your judgments. Unless there are unnecessary boring repetition of the same point over and over. If there are separate shades or nuances, yes, by all means cite.
No, just
Sorry, yes.
With regard to that thumb impression, even a thumb impression is not a suspicion, my lord. Merely because the section.
This is very relevant.
That it has an affixation mark, thumb impression is one of the affixation mark.
And even section 63A provides for that. Or affixes a mark.
Exactly, our Calcutta High Court is saying paragraph 23 and 24.
Absolutely.
So, my lord, that cannot be. And again, my lord, Calcutta High Court has reiterated. If you raise any suspicion, the caveator has to dispel it out. Not the propounder. Propounder is to show that execution was done.
23-24.
23-24. This is reported in 1989 SEC Online, Calcutta, page 38, by AIR 1991, Calcutta 166. Milord, may I just add one line, Milord? Here.
Yes.
Milord, as an explanation, Milord. Suppose, Milord, he had a best case, Milord, if something was wrong. my lord, a signature can be forged. My lord, thumb impression cannot be forged because fingerprints are different. He could have done it, my lord, very well by bringing up, because there was another document on record which shows thumb impression. And my lord, now, my lord, I add on to say and conclude, my lord, today, my lord, by saying that the trial court has, my lord, those in a probate proceeding, not only we have to prove, but court has to, from conscience, has to be clear, my lord, there is no fraud playing on. So, my lord, this conscience, my lord, court was very well, my lord, taking into note of that document of 2003, where thumb impression was there of the testator. So, my lord, court made himself doubly sure that whether this person who is a literate person, a court clerk who has a knowledge of law, why he is putting a thumb impression, and my swearing of severness of hand, my lord, on deposition, is it correct, my lord, or my lord, I have just said it like that. So, my lord, that 2003, which is again a registered document, the thumb impression of the testator was found there. So, my lord, after the death of the wife, my lord, his hand started after 2 years trembling. Similar to that extent, also, I would say, my trial court was justified in clearing the conscience that yes, this is the wish of the dead man, and duly registered and executed before the registry office. May I continue on the next?
Heard in part for further hearing, June 30, 2025.